Yes, yes.
Perhaps it's appropriate that I mention the fact that you strictly adhere to the time frames, simply because we are running behind schedule for more than any other reason. So we probably can start the proceedings now.
The prosecution may proceed.
The permission to court. May I proceed?
Please.
A very good afternoon, Mr. President, honorable judges of this trial chamber. We are prosecutor in the instant case of the prosecutor versus Robert Stanley in the situation in Zuan. And we submit that we bring this case to you today for a crime which is so egregious in international law that it warrants exceptional authority of this court, and it warrants that this court be extremely cognizant of the actions that have been undertaken in the situation in Zuan against a vulnerable minority population, namely the Filos. Mr. President, Your Honours, the situation in Zuan is characterized as the archipelagic state of Zuan, which consists of two conflicting communities, the Sophists and Filos. The accused, a Sophist, has been charged with the crime of committing genocide against the Filo population through a series of policy measures, including but not restricted to forced abortions, forced pregnancies, forced sterilizations, even active euthanasia. These are some of the many policies, and we will seek to establish how Mrs. Cranky, the accused, in collaboration with Carlos Puyol, the premier, and in collaboration with the state authorities, had executed a plan so as to systematically destroy the entirety of the Filo community, and forwarded a plan which, albeit was shrouded in science, was but a manifestation of their prejudices. The office requests the court to refer to the facts as and when required on page numbers Roman numeral 15 and 16 of our written submissions. The prosecution shall rely upon such facts to substantiate four particular arguments which are placed before your honours as such. But before I go about to enumerate these arguments, the prosecution would like to submit two compendiums, one with respect to cases and one with respect to the articles. We shall be referring to the same in addition to some of the annexures that we will be submitting, which you already have access to. If I may proceed with enumerating the four issues that we shall be dealing with. The four issues are, firstly, we shall be stating that the accused be committed for acts of genocide under Article 6. We submit that the accused is liable for 3 counts of genocide, with Article 6A, whereby he had caused serious bodily and mental injury to the victims who belong to the Filos community. Secondly, that he be charged under Article 6C of the statute, whereby he had inflicted conditions calculated to bring about their destruction in whole or in part as such. Thirdly, we submit that he be charged under Article 6B, whereby he had imposed measures to prevent births within the community, thereby ensuring that the community eventually disintegrates. These are the 3 submissions. We will be establishing the objective elements, which are essentially that the Filos are a protected group, that there was dolus specialis or specific intent of certain Clanky to destroy these groups, and thirdly that there was a manifest pattern. We will also establish the specific elements of each of these cases. You shall find these submissions on pages 1 to 6 of our written submissions. Arabic meaning. With respect to our second issue, we will be specifying that Jordan Slanky is individually criminally responsible under Article 25(3)(a) as a co-perpetrator and under 25(3)(d) as an accessory. Our fourth issue will be dealing with the arrest, and we state that the arrest was valid under international law and that no particular law was violated, which is something that has been claimed by the defense. Our fourth issue is a sui generis application, where we request the court to pass an order to forfeit the instrumentalities of the crime of genocide, which were achieved through the acts of piracy which had been persisting in Zuan for a long time. These are our four issues. We shall be substantiating upon them. Our victims are three. The first victim, Mr. Eugene Young, is a journalist, and he will be providing information into the mens rea of the accused, Mrs. Clanky. He has been in contact with the accused for long, and we believe he is, because of his reputed position and because of his unique character and association with the accused, he will be valuable to establishing mens rea. Secondly, Mr. David Akeroff will be providing how the policy, which was essentially at the face of it a scientific policy, was indeed a manifestation of the prejudice and was a systematic policy to create disintegration of the Filipino population. The third witness is an unnamed individual, a septuagenarian. If I may just take 30 seconds to summarize. Is a septuagenarian who will establish what the effects of the policy of Mrs. Clanky was and how widespread these policies were. With that submission, we would like to close our opening speech. Thank you.
You may proceed.
A very warm good afternoon. Honorable panel of the trial chamber of the ICC, the prosecutors and the defense counsels. I am Divya Joseph. I am the victim's representative in the case of Prosecutor versus Jordan Slanky, 2019. Honorable panel, this is a case where systematic and planned genocide was committed, targeted against a specific racial and ethnic community, that is Filos. We understand that Jordan Slanky, the accused in the present case, is a world-renowned geneticist, is an expert in genetics and heredity. We accept that he is a smart person. We accept that he has expertise and brilliance to implement such a policy in such a way that any layman in a first impression wouldn't be that it is a genocidal plan. It's very well categorized. But if you look into the implementation of the plan and the policy, it is very clear from the very fact that it is a doctored policy which is targeted specifically towards the Filo communities, which is a victim in our case. Through our arguments in cross and shield, the counsel for the legal representative for the victims here will be establishing that the manner in which the accused was arrested, that is Operation Dexter, is completely legally valid. May I bring it to the notice of Your Excellencies that this is a case of genocide, which is the crime of crimes, which is of extreme grave nature and is accepted as a just cogence norm to be banned in all countries. So, in such circumstances, it is submitted that deceit may be used to arrest a particular person to prevent the crime. But a promise which is given should not be broken, which was not broken in this case. So we defend Operation Dexter, and then moving on, we prove systematically how the policy was doctored and how it specifically targeted Filos and how the victim suffered grave loss because of the policies implemented by the accused himself under his discretion and by himself with full intention. Moving forward, we prove that the accused in the present case had the genocidal policy intent way back, and he had always targeted them. Even he gives lectures, he cites them as racially and genetically backward community. You understand that he has always had this intention of eliminating Filo community from the face of earth, and especially from his own country. He's expressed his desire in many ways. Moving on, we specifically bring it to the notice of this panel that the causal link between the actions of the accused and the harm suffered by the victims in this case are very clear. You see that because of the actions of the accused in the present case, it may not be evident as of today, but because of the policy already implemented through the last 8 years, it is seen that they have almost neared extinction. They have imposed conditions to restrict birth to an extent that in another 20-30 years, if effective methods are not brought out, the whole race may be extinct in the country of Zuan. It is also established through our cross and sheep that philos in Zuan are very distinct from the philos around the world. So any harm caused to the philos in this particular country of Zuan itself is enough to cause the extinction and extermination of the whole race. Finally, we prove that through our submission for the sake of this honorable panel, that the victims here have been victimized to a grave extent, and that we seek reparations and rehabilitation of the same from the accused and the Zuanian government itself. Much obliged.
The defense may proceed.
The defense counsel seeks permission to move to the dais.
Sir,
A very good afternoon to the President, Your Excellencies, and the fellow counsels of the Office of the Prosecutor and the legal representatives of the victims. This is the first defense counsel, Srijan Somal. I'll be presenting the opening statement as well as will be conducting the examination in chief of the witnesses. Also, my co-counsel Pratika Indrakya will be conducting the cross-examinations as well as will be delivering the closing statement. Your Excellencies, the defense stands before this honorable court in the case of the prosecutor versus Jordan Schlanke. Your Excellencies, the charges against the accused in the present case are under Article 6 of the Rome Statute, that is the crime of genocide. First of all, the counsel would like to state that it is the burden of proof to prove that these charges against the accused is on the prosecution, and the prosecution has to discharge this burden of proof beyond reasonable doubt as given under Article 66 of the Rome Statute. Now coming on to this, before coming on to the charges, the counsel would like to highlight the fact before this honorable court that the accused was brought before this honorable court in an illegal manner by the Operation Dexter conducted by the Labour Republic in coordination with the Office of the Prosecutor, and the Office of the Prosecutor has promoted the same. Your Excellencies, the accused's basic human rights of right to liberty and security and right to a fair trial as well as the right against arbitrary arrest have been violated. Your Excellencies, the said rights have been mentioned in the Article 9 of the ICCPR, which has been ratified by both of the countries, Xuan as well as the Labour Republic. Also, the right to fair trial under Article 64, Clause 2 of the Rome Statute has been violated. Your Excellencies, the accused was manipulated, misled, tricked and coerced into his arrest, which violates his rights, basic human rights, for which the counsel pleads before this honourable bench that the proceedings should be stayed in proceedings against the accused should be stayed in the interest of justice. As given in the case of prosecutor versus Lubanga, that if the rights of the accused are harmed in order to bring him to justice, then it is the misuse of the reasons by which the ICC was established. So this is against the ethics of ICC. So the counsel pleads that these proceedings should be stayed. Furthermore, coming on to the charges of genocide, firstly the counsel would like to highlight the fact that there are no relevant facts to suggest that any mental or physical harm was caused on the fellow population of Xuan so as to establish a liability under Article 6b of the Rome Statute. First of all, the counsel would like to state the Travaux Perpetua of the Genocide Convention explicitly state that the mental harm imposed must be more than a minor impairment of mental facilities. In the present case, Your Lordship, there are no relevant facts to suggest that even there was a minor impairment of mental facilities. Moving on to the charges of genocide in the Article 6d of the Rome Statute, the counsel would like to state that there are 5 major elements of crime which must be satisfied. First, that the accused must have imposed some measures on some persons. Secondly, such persons must belong to a particular racial, religious, national or ethnic group. Thirdly, that the accused must have intention to destroy the group in whole or in part. Fourthly, that the measure should be to prevent birth within that group. And fifthly, there should be a contextual element. Your Excellencies, the defense denies the presence of second and third element of crime in the present case. Firstly, that the measures imposed were not imposed on a particular racial, religious, ethnical, or national group. They were imposed on the entire population of Sichuan. Also, all the measures were neutral to all the population. Also, the accused did not have any specific intent, also known as Dole's specialist, as given under the case of Prosecutor versus Al-Bashir. He did not have any specific intent to destroy a particular group. All he wanted was to seek human resource development of Sichuan with the help of eugenics. Your Excellencies, eugenics is a science which is followed in many countries, and no such country has been brought before the ICC or any other international authority for that matter. For example, your Excellencies, the Council would like to state the condition in China, which has a legislation called Zhonghua Renming Muying Baojiangfa. This legislation literally translates to Law of People's Republic of China on maternal and infant health care. This legislation provides for active forced sterilizations as well as forced abortions for any person who has serious genetic disorders. The Council would like to state that these are follows in all the countries, and in the present case also this was race, ethnicity and nationality neutral. So the accused should not be tried for the offence, and the Council would like to conclude the opening statement with this. Thank you.
Yes. You may.
Thank you, Your Honours. Your Honours, I, in addition to being the opening speaker, will also be conducting the chief in-examination of the witnesses. Before the witness is brought to provide witness, we just have this one clarification which we would really appreciate if the presiding judge and the chamber at large would be able to address. Under rules 134 and 134 sub rule 3 and rule 140, we will be able to provide you with the same. Could the tribunal please provide if objections are allowed in the instant case, since there has been no agreement or rule with respect to the same?
134?
134 sub rule 3 and 140.
Okay.
Are objections to be allowed then?
Can you make the submission again?
Your Lordships, Your Excellencies, there has been no determination in the rules either of SICTA or any general rule as to whether or not objections are to be allowed in an examination. So, if you could provide an order to the same.
Yes.
Thank you, Your Excellencies. We now bring forth witness number 1, Mr. Eugene Young, to depose before the chamber. May I begin?
Yes.
Thank you.
Good morning.
Mr. Young, could you please restate your name, your nationality, and your occupation?
Yes, I am Miss Eugene Young. I am 40 years old. My nationality is the United States of America, and I am a journalist by profession.
Mr. Young, how do you know the accused, Mrs. Jordan Stanky?
I have been conducting an in-depth research on Mr. Jordan Schlanke. As a journalist, I have been interested in writing a biography on his life, and that is how I was introduced. That is how I know about Mr. Jordan Schlanke.
How were you introduced to Mrs. Stanky?
I was introduced to Mr. Schlanke at his convocation at his undergrad, which is where I met him, and he was introduced to me by one of his professors.
Mrs. Stanky, what is your credibility as a witness, as an individual? How can you say that you can rely upon your evidence of that you give on Mrs. Stanky today?
You can rely upon my evidence today because A, I have conducted in-depth research on his life and his achievements, and also I will be an unbiased party because I am just a journalist and I don't have any interest in this process.
Thank you, Mrs. Clanky. Mrs.
I
Clanky,
take it that you are a responsible journalist.
I hope so.
Mrs. Clanky, could you, in addition to the question raised by the Honorable Judge, could you specify what your credibility as a journalist and whether or not, what is your position as the same?
Yes, I have won several accolades for my academic work, and also I am a renowned journalist. And at the same time, I have also undertaken a lot of research on minority rights.
Okay, thank you, Mrs. Clanky. Mrs. Clanky, coming to your testimony, you specify that you have had the luxury as well as the misfortune. Could you explain why you use these two seemingly contradictory terms?
Yes, I mentioned luxury because I have always believed Mr. Schlanke to be an ingenious person. I feel that he is a mind of unparalleled intellect, which is why I said luxury when I met him at his convocation process. This is how his professor introduced me to him. He was somebody who would be capable of achieving so much more. And I would say misfortune because I have also, as I mentioned, I have conducted a lot of in-depth research into his work, and I am of the opinion that he has used whatever his academic qualification and the work that he has undertaken, he has used it with an intent to destroy a particular, manifested in his prejudice to a particular community. He has used this work with the intent of destroying that very community.
Okay,
How,
thank you.
how much of your opinion would be subjective?
Of course, as a journalist, I think a lot of my opinion would be subjective, as I am still, I'm yet in the process of writing a biography. But I still believe that I come from an objective point of view, since I don't seek to derive anything by posing in front of the ICC today. And I come with my objective mind.
Is it fair to say that you have been observing the accused for a long period?
Yes, because I was very intrigued by his persona itself. I have been keeping a track of his work for a very long time, and whatever achievements he has made, whether in the scientific community or his accolades, I have been keeping a track of all of it.
Thank you, Mr. Young.
I just have one question for you. You acquired this knowledge by virtue of the special relationship you had with the defendant.
Your Excellency, may I answer your question, Your Excellency? Thank you. Your Excellency, we have had interactions on both a public and a professional, both on professional and public levels, and that is, of course, we're not so to say friends, but since I've always been interested in his life, we have so to say maintained touch in that regard.
Yeah. Now, yours is profession and engagement.
Yes, Your Lordship.
So there are certain privileges that are attached to it. There are certain privileges such as confidentiality that's attached to it by virtue of that special relationship. You are privy to that information, aren't you?
Your Excellency, I wouldn't say that I am privy to any of his confidential information. On whatever I have previously deposed in my written communication to the ICC, all of it is dependent on the work that he has done, and all of that work is in public discourse. So my opinion of him is based on what he has not only advocated in his own research papers and written documents, but also what he has himself said in his own public discourse.
May I proceed?
Yes.
Thank you, Your Excellency. Mr. Young, you say in your testimony that you believe Jordan Schlanke wanted to purify humanity's gene pool through confrontational readings. Could you explain this statement?
By confrontational riddance, first of all, I meant that he was essentially employing an active method to get rid of a particular community, which is why I said confrontational riddance. And when I said
humanity's gene pool, why do you think Jordan Schlanke wanted to purify humanity's gene pool?
So, Mr. Schlanke has always been of the opinion that the philo community is irrelevant irrelevant, and the community comes from a certain sense of economic, social, and political backwardness. And this is something that he has advocated through all of his discourses as well. So, with my
So did you have a sense of revulsion? Did you realize that?
No, Your Excellency, I did not have a sense of revulsion.
Proceeding, you mentioned that Jordan Stanky, what particular viewpoint do you think Jordan Stanky had of the philo community per se?
As I mentioned previously, I felt Jordan Schlanke was again of the opinion that the community was absolutely irrelevant. They came from a background of social, economic, and political backwardness. They had a lot of criminal, and it was essentially economic and social backwardness that Mr. Schlanke attached to the community. And he would also always take into consideration the criminal antecedents of the community.
But wasn't it a fact that this community was criminal antecedent or socially and economically backward?
Your Excellency, that fact was established through a report and through having undertaken research, which was undertaken by Mr. Schlanke himself. Not otherwise. This is something that was advocated in the public domain by Mr. Schlanke himself. And how do we believe in that when he himself comes, when his opinions are itself manifested in prejudice? So what
Was just one question, please. Was that study specifically targeted towards the philo community, or after the study did he illustratively refer to the philo community largely corresponding to certain findings he made?
It cannot be said that the study was specifically directed towards the philo community, but considering his opinion that the ideology that he has always had in this regard, there will always be a certain doubt as to whether this study was specifically specifically directed towards the philo community.
That would be a matter of opinion only.
Yes, that is my journalistic opinion.
Coming to two questions, and very briefly, please. Are you aware of the Trident Action Plan?
Yes, I am.
Do you think that the Trident Action Plan was enforced by Jordan Stanky for achieving any of his personal ambitions?
Yes, I believe that with having undertaken the Trident Action Plan, Mr. Schlanke was attempting to gain some sort of a political mileage, because he always had political ambitions. But if he started from the bottom and not made use of the Trident Action Plan, he wouldn't have found favor with the current government in power. So he would have had to start from the bottom and work his way up to the top. But having undertaken this Trident Action Plan and found favor with the ideology, he was sort of able to gain political mileage.
At this point, we would like to submit Annexure 4 with regards wherein Jordan Stanky in a public interview has expressed his political ambition and also his viewpoints on the philo community. And with that, we would like to end this.
The document is already briefed to us.
Yes, sir. On this, we would like to submit it as exhibit.
As an exhibit.
And with that, we would like to close this thing. Thank you.
The victims will proceed.
Good afternoon.
Good afternoon.
Is it correct to say that since you are writing a biography, you've been in frequent contact with the accused?
As I mentioned, both public and professional and personal contact.
Both professional and personal ones.
Yes.
Is it also correct to say that he has cited philo community as genetically backward and in all his public endeavors like speeches, etc.?
Yes, he has.
Also, is it correct to say that he overlooked the implementation? You obviously know about TAP and his involvement in TAP. So, do you agree that he overlooked the implementation of TAP?
Yes, he did overlook the implementation of that.
One final question. Is it correct to say that Carlos Puyol, when he was granted amnesty, he offered the amnesty deal, he threatened only philo community to get the amnesty deal?
Could you please repeat your question?
Carlos Puyol was offered an amnesty deal in this case. Is it correct to say that he threatened only philo community to get that amnesty deal from UN?
I apologize, but I will not be
Counsel,
able
would you
to depose.
would that question be relevant because you're now
Depose with regard.
charging somebody else? Carlos Pio is not before the court.
Your Excellency, that will be relevant to prove that the victims in this case are fellows. The targets of the policy were fellows.
Ms. Counsel, unfortunately, I won't be able to give you a testimony to that effect because I would only be able to
You
depose on
don't
Mr.
have to say
Schneck.
more. You don't have to say more.
Much obliged, Your Excellency.
The defense will proceed. The defense counsel seeks permission.
A very warm good afternoon to Your Excellencies, the witness, the Office of the Prosecutor and the legal representative of the victims. If it may please the bench, may the counsel proceed with the cross-examination. Much obliged. You stated in your chief examination that you've won several accolades and that is why you're a credible witness. Can you state 3 of those accolades?
My accolades are with respect to my academic accolades, not my journalistic accolades. And my academic accolades would involve the fact that I have received honorary degrees from several universities and honorary doctorates from several universities. I apologize, and I'm also a Rhodes Scholar.
So, how do you know the accused?
I came into contact with the accused at his convocation ceremony. I was introduced to him by his professor.
How do you say that he seeks to purify the gene pool?
I say that with my professional journalistic opinion because having followed his work for so many years and his public discourses in which he has claimed this himself.
I'm so sorry that I could not explain you the question well. The question is, how does he seek to purify the gene pool? Like, what methods does he use to purify the gene pool?
I think the Trident Action Plan is a very evident manifestation of how he seeks to purify the gene pool.
Point to be noted, Your Excellencies. Further, you talk about purgatory panacea. What does that mean?
By purgatory panacea, I mean that his employing of a very violent method to... So essentially, Mr. Jordan Schlanke, in the garb of doing something good for the society, he is essentially employing negative eugenics, right? So when I say purgatory panacea, what I essentially mean is that he's employing violent methods in the garb of doing something good for the society.
To be more specific, purgatory panacea is the final way of removing someone, like eradicating, correct?
Agreed.
And in your testimony, you say negative eugenics for him is the purgatory panacea.
I do.
Point to be noted, Your Excellencies. You stated that for Jordan, a fellow is someone who has genetic infirmities. In the chief examination, you stated, I'm so sorry. So, do you believe that the fellows have genetic infirmities?
I am not a geneticist. I cannot answer to that effect. That is his own, that is Mr. Jordan's prejudice that I am confirming in this court.
Much obliged. So, you stated that there was some infirmities and he used negative eugenics to remove them. That is the purgatory panacea.
I never stated that there were infirmities, Ms. Counsel. I only stated that this was his opinion that there were infirmities.
Thank you. So, you stated negative eugenics is the purgatory panacea?
I would, yes, I would confirm to that opinion.
Thank you. You say that it's a very ruthless act. This very act is ruthless. Is that true?
Yes, I do believe that the Trident Action Plan in its entirety, especially the last phase of it, was extremely good.
And you also stated that you're not very well versed with the science and you do not know anything about eugenics.
I will not say that I don't know anything about eugenics.
But you're not an expertise.
I'm not an expertise, but at the same point.
Your Honor's relevance.
Your Excellencies, the relevance would be
I think the objection is over.
would be substantiated further. Much obliged. So, since you're not an expertise, you do not know intricacies of eugenics. You would do you think there were any other ways to remove these infirmities?
I would like to be of the same opinion. I do not believe that there are infirmities, and if there are genetic infirmities, if any, it is not the government's responsibility, so to say, to remove genetic infirmities. There could have been several other ways which the government could have employed for the development of the country, not genetic infirmities.
Could have employed, that is your opinion.
That is my opinion on human rights.
Point to be noted. Further, I put to you that cystic fibrosis is a genetic disease that is prevalent in fellows. Further,
Objection. Relevance.
the relevance will be substantiated in the closing statement, Your Excellencies. So, you say that it was done for political ambitions, am I right? What political ambitions are you talking about?
His political ambition being that he wants to get a party ticket, he wants to be
Party ticket.
Yes,
I put to you,
nominated, yes.
I put to you, he's already in the party, he's the chairperson of SCD.
That I agree with that, but wouldn't you want to move to?
Objection, Your Honor. This says SCD and fact SCD.
That might be to your advantage.
I agree with you, Ms. Counsel. However, he was in the SCD. The SCD was a specialized department. He was not per se in the executive itself.
I'm so sorry to put the wrong question to you. So, you talk about a political mileage among the top brass. I put to you his cousin, is already the second in command in PTA. He had very good relation with the former premier of the country. Do you think he needs more political mileage than this?
Objection, Your Honor. Speculative.
It's not speculative.
Carry on.
Speculative.
I think you have to be a little careful in questions you ask.
I'm so sorry, Your Excellencies.
May I answer this question or no?
No.
Also, you stated that he volunteered for the enforcement.
Yes, he did.
So,
He oversaw the enforcement.
Okay.
Not volunteer, he oversaw the enforcement.
So, what do you think are the qualifications for enforcement?
Ms. Counsel, are you asking me about the enforcement of the TAP?
So, what do you think so you think he volunteered and he did not have the requisite qualifications. So, what do you think are the requisite qualifications?
So, under the TAP, he essentially undertook sterilizations and abortions. Now, from my knowledge, is a geneticist, and he, from my knowledge, has studied biotechnology and gene mutation. So, in order to undertake these two actions of sterilizations and abortions, you need a certain medical qualification.
But even in this process, he was assisted by researchers and scientists, and not medical officials per se.
I bring to the notice of the bench that the witness states that sterilizations and abortions were done, but it is an undisputed fact that positive eugenics, that is forced pregnancies, and differential promotion of. Indeed. No further questions. Thank you.
Your Excellencies, we would like to thank the witness and would like to discharge her from duty, and we would like to thank the defense for essentially examining rather than cross-examining, and we hope that we can refrain from misstatement of facts.
I think you can leave that to the tribunal.
Yes, we can. Yes, we can. I have to apologize, Your Excellencies. Your Excellencies, if the witness be discharged, the prosecution would now like to call witness number 2, Mr. David Ackroyd. While the witness is on their way, Mr. David Ackroyd is a bureaucrat who has been in a government position at a very senior. Through the witness, we would like to establish that there were manifest and systematic patterns into how the acts of genocide were conducted, and also establish the mens rea of all conducting the acts. How much time do I have? I have 5 minutes. Could I be giving a bell at 2.5 minutes? In fact, give it at 3 minutes. At the 3rd minute, with 3 minutes remaining. Could you please state your name for the record?
David Akarov.
Your nationality?
Juan.
And your age?
58.
58, very well. Thank you. What has been your occupation? What were you?
I was a senior bureaucrat at the Department of Domestic Affairs.
And were you in a relatively senior position?
I was a senior level bureaucrat.
And so you will be aware of the demographic situation of Suwan, is it safe to assume? Very well, thank you, Mr. Akarov. Mr. Akarov, coming to your testimony, and even before that, however, is there a considerable difference between the Philos and other groups of Suwan? Is there objectively identifiable difference between these two groups?
Yes. For starters, for example, they speak two very different languages.
Right.
So, so while the Philos speak in the Mezut tongue,
right.
The Sophists speak in a European language.
Right.
So that is one. Second,
are there any characteristics which are different?
Yeah, for example, they have their practices, right? So they practice the pagan faith,
right.
which is very distinct.
Would you say they have a different culture?
Yes, they're mostly conservative. They're mostly conservative.
Conservative, not
yeah.
Conservation is what they incline towards, not conservative.
Yes.
Conservative or orthodox, right?
Yes.
Very well, thank you. Mr. Akarov, are you aware of the DAP and the Zuan Population Control Implementation Act?
Yes, I am.
And you mentioned in your testimony that negative eugenics was conducted and that these particular methods were doctored against the Philos. Why do you say that these particular projects were doctored against the Philos?
So basically, I wouldn't say that it was doctored if there was a particular objective standard by which this entire process was carried out. However, what we saw was a shifting, so the presence of relative standards, right? So in different areas, there were different standards by which a person was determined, whether a person was determined as to whether he or she had to undergo sterilization or not. So if you have then it's very difficult to tie down something to an objective standard, and automatically you are opening of impropriety to come in.
Point to be noted, Your Honours. One very brief last question. Do you think that the implementation of these policies have had any effect upon the Philo community?
They have had severe adverse impacts on the country and the population. For example, the Philo population in the last 10 years has come down by 50%, something which is incredible. Not just that, so that is physical harm. And then obviously because of this regime and the kind of things that are going on, you've had Philos being constantly under mental pressure of being mentally in a constant state of terror. So there is both physical as well as mental harm.
Again, point to be noted, Your Honours. And with that, due to the paucity of time, the chief of the witness is closed. Thank you.
Good afternoon, witness. So, is it correct to say that you have your contacts even now in the bureaucracy and the ministry?
Sure, I have colleagues and friends.
So, is it common knowledge that there was a malified intention between Carlos Piol and accused Mr. Jordan Schlanke towards Philos?
I've had my colleagues and my friends inform me that in fact these two people were quite resentful of the fact that the Sophists and the non-Philos were constantly going off to fight in wars and putting their lives on the line to build infrastructure and so on and so forth, while the Philos who were rejected by the army stayed back home and enjoy the fruits of the efforts made by the army.
Thank you, witness. Further, if I put to you that Jordan Schlanke effectively hated Philo community, will you deny it?
No, I will not.
Thank you, witness. And one last thing. Is it correct to say that in the memo that you mentioned in your communication to the ICC, the registration of people with feeble mind, idiocy was made mandatory? Is that correct?
Yes.
And differential birth rate were imposed on these people? Is that not correct? That be all right.
Defense counsel.
Good afternoon. Is it true that you lost to the brother of the accused in the elections?
The cousin brother, yes.
Point to be noted, Your Excellencies. So, do you think eugenics is correct?
I am not against eugenics as a concept. However, I do differentiate between what is positive eugenics and what is negative eugenics.
How do you do that?
In the sense that when you're talking about positive eugenics, you're talking about active efforts to promote a particular gene or characteristic which you feel is advantageous. While when we're talking about negative eugenics, you're taking concerted systematic efforts to stamp out what you consider are problematic characteristics or problematic genes.
Thank you. So, what you state is, so what was happening in Xuan?
In Xuan, it is negative eugenics which was being carried on very like in a very brash and brazen manner, wherein people who were considered not to be according to the tests, people who were considered to not meet certain standards were made to go forced sterilizations, which is absolutely like and extremely condemnable.
Indeed not, Your Excellency. As the council, since the witness talks about positive eugenics and negative eugenics, the council seeks to know what, since he elaborates on eugenics, so what according to him was happening in Xuan. And the point to be noted is that he states only negative eugenics is happening in Xuan. Further, since you accept the fact that eugenics is not wrong per se, you talk about some malign intention. Is that true?
Yes, indeed.
So what is the malign intention in the present case?
So like I've said, so I've had colleagues at my previous workplace, the Department of Domestic Affairs, inform me that there was an intention of the ex-premier as well as the accused to, and they were resentful to the fact that the fellows who were rejected from the army and the armed forces were staying back and enjoying the fruits of the efforts that the sophists and the non-fellows were, they were going.
Could you tell me who that person was, a fellow or a sophist, as it was a sophist government?
You can call them up and put them on the stand, and they'll be more than happy to answer that for you.
Thank you. Like you stated, okay. So do you think the campaigns were directed against fellows? Do you think the campaigns were directed against fellows?
Absolutely.
And you also stated in your chief examination that the tests for evaluating whether a person...
I take it that what you're wanting to ask is that we can say with certainty that the campaign was directed against the fellows, that there would have been 1,000 other reasons. Isn't that so?
Indeed, Your Excellency. Indeed, Your Excellency, the council seeks to know the opinion of the witness, that is it. Further, you stated that the fellow population has come down to 50%. What reason do you think that is?
This council has already attributed the reasons. You want to question those reasons?
For the convenience of the bench and also for the council, could you state those reasons again? So you say that there is no other reason for the decline in the population? Thank you so much. So do you also state, so no other population, there was no other decline in other populations? I put to you that it is an undisputed fact that the sophist community, which was the most populated in Xuan, is now the third largest population and not the most. That decline is more than 50%. With that, no further questions. Thank you.
Thank you. Your point is taken. You are discharged.
Your Honors, the before I start with the examination of the witness, we would like to establish that the witness has redacted their name, and as such, we believe that it is our duty to provide the solemn undertaking to the witness under Rule 66 of the under Rule 66 of the Rules of Evidence and Procedure. Could you please repeat after me? I solemnly declare that I will speak the truth.
I solemnly declare that I'll speak the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
With that proceeding and beginning with the chief examination, could you please provide us with your age?
Sir, I'm 75 years old.
And in your testimony, you mentioned that there was something wrong which was done to your daughter. What was that wrong?
So actually, my daughter was pregnant, and she was forced to undergo an abortion. And during the course of abortion, she lost her life, and that is what is the wrong which my.
How old was your daughter?
She was 15 years old, sir.
And how did she come about to take this abortion?
Sir, I didn't understand your question.
How did she come about to take this abortion? Did she take it on her own voluntary accord?
No, she didn't. It was forced upon her.
Did you know of her pregnancy?
Yes, I did know of her pregnancy, and I was completely fine with it.
Did you know of her abortion?
No, I didn't. I was not informed about the abortion, but she studied in a government school, so I went to the school and talked to the headmaster when I came to know that such a thing is going to be done. So the headmaster, he started telling me to agree to the proposal of aborting the child of my daughter, and I said no, we are fine with having the child because he would be helpful in the farm, and we can because child marriages are very common in our community, so I was fine in accepting the child. For me, the well-being of my daughter was more important, and it was completely fine to have a child for a grandson for me, grandson or daughter for me. So, but still, it just happened.
After the abortion, after your daughter undertook the procedure for aborting her child, she died, you say?
Yeah, like my daughter didn't undertake, it was forced upon her because these people are conducting all these media propaganda 24/7, and they're coercing people and manipulating them into doing these things, and creating an impression on their minds that these are for the well-being of them, and ultimately my daughter also fell for that, I feel.
Mentioned there were media campaigns.
Yes, sir. There were media campaigns which showed that this abortion, voluntary abortion, would be for the well-being of these people, and henceforth, and after undergoing such things, only people came to know that it was actually a trickery.
Could I please have an extension of a minute more? So thank you, Your Honors. You mentioned also in part of your testimony that you believe philos and sophists are different.
Yes, sir.
Philos, and on what basis do you assert this difference?
So a lot of basis, sir. Predominantly, we philos. We say we are the people who started the very first food crop in Zuan, and we have completely different ethnicity, completely different value. We have been practicing polygamy, and we have that's the uniqueness of our religion, and most importantly, we are the people who know to cultivate plants in soils which are rid of minerals due to raw water from ocean. We only know the special capacity to do that, and the philos do not know. The sophists do not know that. No, sir. We speak Mizot, and the sophists speak something else from the European origin. I do not know, sir. Sir, sir, that we know, sir. That's our uniqueness. We speak Mizot, and I have never heard anyone else speaking that.
Lastly, in accordance with the manipulation and procedure which was carried out by the state, did the state provide any compensation?
Yes, sir. They did provide compensation, but they said that it is for the greater good of the society, sir. I don't understand that.
Thank you. Thank you.
Good afternoon, witness. Since you are a philo farmer, is it correct to say that your community has devised an efficient and indigenous method of farming where you farm even in soil drained of all minerals?
Yes.
Point to be noted, your lordships. Further, is it correct to say that such untimely deaths happening in government schools were highly common in philo community?
No.
Okay. Is it correct to say that then only your daughter was affected? there were other deaths happening from similar abortions.
Yeah,
Is that correct?
Yeah, due to abortions and such things, deaths were happening. But before the so-called operation or experiments were conducted on us, nothing like that was reported.
The evidence must be given by
Your Excellencies?
the evidence must be given by the witness and not by you.
Yes, Your Worship.
There is a limit to you putting leading questions. Right?
Oh, yes. Further, is it correct to say that your daughter was naive and gullible and was forced into abortion?
Ma'am.
She has already said. Why you are
Your Excellencies, it's a cross-examination, so leading questions may be allowed.
Yes, you can.
Oh, much obliged.
But you are supporting the side of prosecution.
What side are you on?
So you are as good as
Exactly.
examination.
Much obliged, Your Excellencies.
Unless, of course, you are very neutral.
Much obliged.
We don't see that either.
Yes, Your Worship. Further, isn't it correct to say that under TAP regime, Philo community has suffered huge mental and physical harm?
Yes.
Isn't it also true that when the bodies, after the post-mortem was conducted, was the bodies returned to you?
No, but that's a relevant question, isn't it? She is for the victims.
Was
Yes.
the bodies returned to you?
Yes.
According to them, were you also given a memo of their post-mortem report?
I do not know.
I'm not aware of that. You did not get a memo of any statement. Much obliged, Your Lordships. The defense is received.
Good afternoon. So, who do you identify yourself as, a fellow or as a Shuanian fellow?
A Zwanian fellow.
It's just this one question.
A Zwanian fellow.
Thank you. So, you stated that you're a farmer and you've helped a lot in the agriculture. You as a community has helped a lot in the agriculture. Can you name 3 crops that you grow?
See, I'm a farmer and I don't know the...
So answer the question.
Sir?
We know that you are a farmer. Answer that question.
Sir,
Simple question.
I don't recollect the names of those crops. Like, I can identify them if you...
Point to be noted, Your Excellencies. Since you talk about the cultural traditions of the Shuanian fellow, they also grow cannabis. Do you do? So, do you also?
It is pretty relevant.
No, I do not.
You do not? Thank you so much. You also talk about how Shuanian fellows are different from the fellows, and you talk about the cultural traditions. Do you follow all the cultural traditions of the Shuanian fellows?
To a certain extent.
Is it I'm just asking a yes or a no question. Do you follow all or not?
Me and my family, we do follow.
All. Point to be noted, Your Excellencies. Since you reside in Shuan, you are very well versed with the culture there. I just want to ask a very generic question to you. When a sophist male marries a philo female, what is the community status of the child born out of that marriage?
I have not come across any such...
Not come across. Okay, so if I may say another question. What if a philo male is married to a sophist female? Any idea?
No, in my community, we haven't married like that.
Point to be noted, Your Excellencies. So, can you just, for the convenience of the court, can you tell us when were you married? You are 75 right now. When were you married?
I was married when I was around 30.
And what was the age of your wife when she was pregnant?
I have 2 wives. One is 60 right now, the other is 50. So you might calculate their ages.
Thank you. Okay. So, do you believe, in your opinion, do you believe, according to the medical science, that it is healthy for a person to get pregnant at the age of 15?
I'm a farmer. I don't know many things about
okay,
medical science, but in our community it is very common.
It's okay. Thank you so much. No further questions.
Thank you.
Your Excellencies, the Counsel for Victims now seeks permission to conduct the chief examination of the victim witnesses. Much obliged, Excellencies. First in order, the Counsel for Victims wishes to seeks permission to call upon the victim witness number 3. Much obliged, Excellencies. Good afternoon, witness. Could you please introduce yourself to the court?
My name is Pablo Escobar, and I'm the chief of the Central Bureau of Intelligence, Labour Republic, which is the chief intelligence agency of Labour Republic.
Could you please state your relevance to the instant case?
I was a key person in Operation Dexter, courtesy of which the accused is present before this court today, the ICC.
Could you please explain how this Operation Dexter was carried out?
We were in communication with the accused. We discussed with the accused how there was mounting international pressure on Juan and on the accused, and how the accused could be arrested at any moment by any of the given investigative agencies, and how he was always under the risk and threat of that. And in furtherance of that, we also discussed with the accused just the possibilities of safeguarding the accused.
Point to be noted, Your Excellencies, just the possibilities of safeguarding the accused were discussed. Could you please explain in detail what was your communication exactly on these possibilities?
There were various possibilities that were discussed, however no offer were placed, but the various possibilities discussed were like amnesty, and the amnesty like the one that was granted to Carlos Puyol was also discussed. However, nothing concrete was offered.
Point to be noted, Your Excellencies. As the last question, what did your authorities do after the accused entered the territory of Labour Republic?
Once the accused entered my country, the Labour Republic, we immediately arrested the accused, and while arresting we informed the accused why he was arrested, which was for genocide as confirmed by this court, the ICC. Further, after this, he was produced before the Supreme Court of Labour Republic in accordance with Article 59 of the Rome Statute, which requires us, after getting custody, to produce the accused before a domestic court.
No further questions yet.
Your Honours, before beginning with the cross-examination, the Office of the Prosecutor would request to issue a clarification to the bench if possible. We here are conducting a cross-examination as per the rules of procedure. However, the nature of this cross-examination under Regulation 52 of the Regulations of the Office of the Prosecutor are only in furtherance of the examination, because we share that relationship with the legal representatives of victims, if that is permitted by the court. Thank you, Your Honours. Mr. Puyol, did you or any of your agency enter the territory of Zuan physically or otherwise?
I'm sorry, you said Mr. Puyol, Mr. Escobar.
Mr. Escobar.
Yeah.
Apologies.
No, none of my people entered or infringed upon the sovereignty of Juan, not at all.
How did you contact Jordan Schlanke?
There were various methods used by our agency that I would not like to disclose openly. However, we did not breach the sovereignty of Juan, that I can assure you of.
When did you plan on operating and finalizing Operation Dexter?
So the court issued an order for the surrender and arrest of Mr. Jordan on November 5th, 2018, and the accused was in our custody on November 15th, 2018. So all of the operation was conducted within these 10 days.
So just another question. No planning was done prior to the issuance of the arrest warrant. Am I correct?
No.
Were there human rights of Jordan?
So we discussed with him the possibilities of safeguarding his safety, his interests, and he was assured that he would feel safer in our country. That is why he chose willingly on his own accord to come to our country, the Labour Republic.
Is there a provision in law in Labour Republic which allows for such forms of arrest?
our country does follow the Frisbee doctrine. It is integrated in our constitution and in international law. So, which states that even if there is a dispute on whether there are irregularities in law related to the arrest, the court still has jurisdiction. So that is a principle that is enshrined. However, I do believe the arrest was totally legal because it was done on our soil.
Point to be noted, my lord. Article 59, 88, 86 of the Rome Statute fulfilled. Were there any egregious human right violations of Jordan Slanky, and if not, how did you ensure the same?
There were no human right violations. He came to our country willingly, as I've stated before. He was arrested, and at the time of the arrest, he was clearly told what he was arrested for and why he was arrested, all of that. And we followed all due process in bringing him before the Supreme Court of our country in accordance with the Rome Statute.
Did you approach the state of Zuan for the same request?
No, we did not, because based on what my team informed me of, following other diplomatic channels for extradition or other such affairs could have had many negative connotations. For example, just to clarify, there could have been a repeat of what Carlos Puyol did. He could have, because of his political standing in the country of Yuan, he could have threatened the Philos, and that was something we could not afford. So that is why we did not explore that option based on the information that was given to me by my team in the intelligence.
Why did you specifically not follow the extradition treaty, if there was any?
Because we believed that using his political influence in the country, he could trigger measures that would make it about various different issues and protect him. So yeah, that is why.
Thank you, witness. No further questions, Your Honor.
Good afternoon. So, is it true that your contribution for which you have recognition is for thwarting major terrorist activities?
That is true.
You talk that the articles of the Rome Statute were complied by. What are the Rome Statute articles that you're talking about?
I'm not a legal expert, so I could not give you a definitive list. But however, I do know the most important one that we recognized, Article 59, was duly followed.
And you also talk about the compliance with international law and international obligation. This question is only imposed upon you as you've stated in your deposition that all this was followed. So can you just tell us that what international law and what international obligation are you talking about?
As I've
for the convenience of the court, if I...
Carry on. As I've previously stated, Rome Statute Article 59 was thoroughly followed, which is a very big part of international law. Also, like I mentioned, the Frisbee doctrine was followed, and to the best of my knowledge, as I'm a bureaucrat and not a legal expert, to the very best of my knowledge, based on what my team has told me, all correct international law standards and procedures were duly followed.
So, thank you. So, when did you get the request for arrest and surrender?
Sorry?
When, can you mention the date on which you got the arrest and surrender?
The court issued that request on November 5th, 2018.
And when did you execute it?
The accused was in our custody on November 15th, 2018.
Thank you so much. So, you stated that your intelligence, firstly I'd like to ask you, how was the intelligence gathered by your federal agencies?
I cannot risk that information based on national security.
Thank you so much. I put to you that it is an undisputed fact that surveillance was done. Further, your intelligence mentioned that the accused...
Ask him what he has got to say. You have put a suggestion. Ask him what he has to say. I put to you, you said it.
I put to you that it is an undisputed fact your intelligence agencies did surveillance.
Because of national security, I would not like to state anything further of that.
I bring this to the notice of the bench. So, your intelligence mentioned that the accused possess the same threat as Carlos Puyol. Do you think he had the same powers to do that? Carlos Puyol was the premier of the country.
Based on the evidence that our agency had and the intelligence we gathered, we knew that Mr. Jordan also possessed a very significant political hold on the country, as well as a social one. So we do believe that he had a big, he was hand in hand with Carlos Puyol in executing whatever happened, is what we believe.
So, since when do you have this extradition treaty?
The extradition treaty of 1912.
Okay, so why do you think that the political outreach of the accused would have affected the extradition treaty? That is the procedure established by law. How can you say that the political outreach can affect that?
We believe that because of that political outreach, he could have triggered a clause which states, which would put in dispute that he was a political figure and put in dispute the.
I'm so sorry to interrupt. Can you please be a bit specific about the clause that you're talking about?
I cannot state the name because I'm not a legal expert, as I said. However, I do know that there is a clause that would prevent, that could be misused by Mr. Schlenki, if I may, to refrain from his surrender.
Just to help you further, you've stated that in your deposition, the clause that you're talking about.
Yes, but I do not recall at this moment.
Point to be noted, Your Excellencies. Has your country ratified the Genocide Convention?
Yes.
Thank you. No further questions.
The Counsel for Victims now seeks the permission of the bench to call upon victim witness number 1.
Defense witness number?
Victim witness number 1, Your Excellencies.
Victims.
Good afternoon, witness. I kindly request you to take the oath. I solemnly swear.
I solemnly swear.
To state the truth.
To state the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Could you please state your occupation?
So, I worked as a clerk.
Could you please explain your relevance to this case?
So, I am a Zuanian fellow. I worked as a clerk where I had to take care of the government documents. And so my relevance to this case was I was discriminated against. Fellows were discriminated against. Should I tell you the entire happening?
Yeah, please proceed.
Yes. So this all started in 2008. In 2008, elections were held and everything went haywire, everything went hostile. There was absolute discrimination against the fellows and fellows only, and it was completely arbitrary. In 2010, the TAP phase 1, it was passed, and Jordan Schlenki, who we are completely against, he was nominated to the SED. Now after that, like, it took a sharp turn against us, the fellows. So in 2011, a roster was passed where a column was introduced where it said that only fellows community, only the people who are employed who are fellows will be demoted to menial jobs, and this demotion was completely arbitrary and it was not explained to us why this is happening. Then after that, we all the government employees, we were asked to go through a medical screening.
If I may interrupt, witness, as of now, what the witness has told, point to be noted with regard to the discrimination conducted, especially after the government comes into power and after the accused takes into the position. Yeah, could you please state the scenario after Jordan, that's the accused, enters the TAP?
Yes, like I said, it all went haywire for us, the fellows community. We were threatened that we were threatened and we were discriminated in our workplace. And then 2011, a roster was passed, like I said, where the column was introduced where only fellows were demoted to menial jobs. Then, so all the government employees, we were told...
If I may interrupt, could you please move on to the medical screenings that you mentioned in the testimony?
Yes, that is what I was getting to. Okay, so then like the government employees, they were asked to go through medical screening, but me along with around 50 odd fellows, we were told that we have some deadly disease that needs to be cured, and this can be only cured if we go through some operation. We were not told the details of it in a straightforward manner, because there was a notice issued which was not in a language that we could understand, that I could understand, and I can only understand my Zooth language. and so we did not know what to do. It just all went haywire.
Point to be noted, Your Excellencies, there was a medical screening generally for every employees, and within the subjective standards of the screenings, or the standards of the screening also, there was discrimination, particularly against the fellows. That's all, Your Excellencies.
Yeah. Good afternoon, witness.
Good afternoon.
Witness, could you, for the record, again state what was the ethnic composition of the 50 other people who were ordered for sterilization measures?
They were all fellows.
They were all fellows. All right. Did you know of any other person who was also affected by this sterilization measure?
I just know that the fellows belonging to my workplace, belonging to my village, and other fellow ghettos, they were all affected.
Witness, you mentioned fellow ghettos and fellow villages. Before that, Courtmaster, how much time does the council have? 2 minutes, 30 seconds. Could you give me a tap in 1 minute when 1 minute is elapsed? Thank you. You mentioned fellow villages and fellow ghettos. Were fellows and sophists living in geographically isolated areas?
The sophists were living in the coastal areas, and the fellows, we were living in the mainland area.
Alright. Do you believe that the document that you were made to sign was by the government itself?
Yes.
And you deposed that your consent was forced?
Yes. Can I explain how?
Yes.
So we were threatened with, at least I was threatened that my termination of my job will be done, and I was also told that if I don't go through with this operation, I'm posing a threat to the workforce and the society at large.
Witness,
so
I might have to cut you short because of the paucity of time. I apologize duly. Okay. What was the harm that this act may have caused you, if it did?
It made me go through sterilization. My entire lineage was cut through because of these monsters. I faced mental threat. I faced mental trauma. My job was in danger. It was a horrible situation for me.
There was one last question, if permitted by the court. Do you still work as in the Proletariat Society of Zuan?
No, I do not.
Why do you not work there? Did you resign? Or what was your manner of retrenchment?
I was fired because when I found out about this horrible situation, this horrible ordeal, I protested as anyone would, and because of on the grounds of disobedience, I was terminated from my job.
Point to be noted, my lord. Thank you.
Good afternoon, witness.
Good afternoon.
The council is confused, as you said that your current occupation is clerk, and in the second examination you stated that you do not work for the PTA. So what is exactly that you're stating?
I stated that I used to work for it, and all of this happened, and after that I was fired from my job. That is.
Oh, I'm so sorry. Thank you. So so you talk about menial jobs. How do you define them as?
Menial jobs is something that is below someone's qualifications. People belonging to the fellows community who did not, who deserved better jobs, were given menial jobs just because of their race.
Only the fellow community.
Yes.
Thank you. So you said 50 people were made to undergo the operation, right?
Yes, 50.
So so can you tell me that were you given the test details of those operations, of the medical screening? I'm so sorry.
Of the medical screening, yeah. After the medical screening happened, we were given a subsequent notice in which was in a language we could not understand. It was not in Mezoot language.
So, as in the previous examination, it was as by the examination chief, it was stated that medical screening was done for all of them. So, were the test results and the operation was also done on all of them?
no, operation was only done for Philos.
Okay, so they stated that it's a very serious contagious disease. Am I right?
Yes.
So, keeping in mind the seriousness of the disease, did you not ask for any translations?
We did ask for it, but we were not given a satisfactory answer. And then we were told that our job will be taken away, and we are posing a threat to the workforce and the society. So
how could they say that your job would be taken away? On what basis?
So they threatened us by taking some measures, like they only made the Philos community work overtime. Then they reduced our payment. Then we had to.
I'm so sorry. I think you got my question wrong. I'm asking you on what basis they put you under such a duress. I'm so apologies, Your Excellency. The same has been. Apologies. Since it is mentioned in the deposition, and that is why the counsel was asking such a question. Point to be noted that the witness says various measures. So you stated that except terminally ill and people above 50 were all sterilized. Everyone was sterilized alike.
No, they were not sterilized. The people who had terminal illnesses and people who were above 50, they were spared. But everyone else, we had to go through it.
Everyone else. Point to be noted, Your Excellencies. So you also talked about the sterilization program in the mainland area. So do you think there were no sophists in the mainland area?
I never said that. That is not my contention.
I'm so sorry. You said that sterilization program happened in the mainland area. So do you contend?
No, I do not. I did not say that. I just say that the concentration of Philos living in the mainland area is higher than that of sophists.
Okay, thank you. So you so for your convenience, you mentioned that they would have invoked a termination clause if you did not go under that procedure. What is that termination clause?
That they would fire us if we do not go through with it, and we should go through with it because we are posing a threat to the workforce and the society as a whole.
This was the termination clause explicitly?
Yes, not word by word, but yes.
Point to be noted, Your Excellencies. No further questions.
The counsel for victims now seeks permission to call upon the victim witness number 2. Your Excellencies. Much obliged, Your Excellency. Good afternoon, witness. Could you please state your occupation for the relevance of the court?
I am a third-party private investigator.
Thank you. Could you please state about the source of TAP funds? How was it? Your Excellencies, apologies, Your Excellency. Kindly take the oath. I solemnly swear.
I solemnly swear.
To state the truth.
To state the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Referring to your testimonies about your comments on TAP, could you please state to the court the source of TAP funds?
Essentially, during investigation, what we found was that because the Zuani's government funds were not enough for the accused to carry on his activities, what happened was funding was essentially sourced from piracy and also other measures like organ etc.
Could you please explain this organ trading that you have just mentioned?
So essentially what we saw is that there were a number of policies that were taken out, right, which were essentially inciting hate crimes, or for example advertisements that were brought out by the association of the accused, right, by the thing that he was heading, and these were essentially all made to turn the people or the general populace's sentiments against the Philos, right, which is
so whose bodies were mainly
the Philos' bodies were essentially taken, and when they were returned to the families, they had suspicious marks on them showing that organs had been taken from them.
Point to be noted, Your Excellencies. No further questions.
counsel begins. Courtmaster, how much time is left for the counsel? 45 seconds. Your Honours, in light of 45 seconds being remaining for the prosecution counsel and a sui generis application, Your Honours, we're asking for an extension of time, if permitted. Yes, Your Honours, completely complied with. Witness, what is your experience in the said occupation?
I have vast experience in this occupation. I have worked for many countries in the past. The exact time, year, or other clients I can't tell you because it's a private
sorry
affair.
to cut you short. Considering the fact that you have relevant experience in international matters, do you believe that the TAP reports could have been there without accurate funds?
TAP could not be carried through if the funds were not procured through another source. That is to say that if it was only the government sourcing TAP, the government under any circumstances could not have the funds, because not only was it at a time of global economic crisis that this started taking place, secondly, what we must keep in mind is that Zuan as a nation itself is also very prone to natural disasters. So most of their funds are already allocated to dealing with things like that. And so experimental genetics or whatever that Mr. Jordan was doing could not be carried out with the existing government funds.
Your Honours, if an extension of 2 minutes may be granted for the aspect of piracy to be established. Yes, Your Honours. What was your mode of investigation? What was your mode of investigation?
I'm sorry, I cannot reveal that to you or in public court. But what I can tell you is during our investigations, whatever was found and was provided is out in the open.
Do you concede that the piracy operations are still undergoing, or have they stopped?
At the point of time when the investigation was going on, piracy was on at full force in the region, and that is all I can confirm.
Thank you so much, Your Honours. It's been a pleasure.
Before beginning, how much time does the counsel have? 1 minute 30 seconds. Thank you. A very good afternoon, witness. How are you connected in the present case?
I am a third-party investigator. I was asked by the Labour Republic to investigate this said matter, and I did so.
Is it not true that you were first approached by the ICC prosecutor himself?
Absolutely.
And why did you reject?
The ICC prosecutor had approached me with a certain sum of money, saying that if I were to testify in the court for that amount of money, I would do so. However, that goes against my professional ethics. However, later when the victim's side came...
I'm so sorry to interrupt. Could you please repeat what you stated?
I was asked by the ICC for a sum of money to come and be their witness. However, as that is against my professional ethics, I refuse to do so.
Point to be noted, Your Excellencies, under falsis in uno, falsis in omnibus, he contradicts against himself. You stated that they needed organs to proceed, like for the research, they needed organs. Why do you think they needed organs?
What I stated was in my investigation, what we found was that all these organs were being used not only for trafficking and for funding these operations that he was carrying out, but also these organs were being used to be tainted and used in reports saying that the fellows are of inferior genetic makeup.
So you also stated that at a later stage this cycle continued and the organs were, they were using organs. So why do you think at a later stage, the policy is already formulated, why do you think at a later stage that they needed organs?
That is something that is not up to a private investigator. For me, investigation was required, and when I investigated, what I saw was this was being carried out. And it was my duty to provide it to whoever was paying me for that information, or was giving me remuneration for investigating that particular matter.
I put this to the notice of the bench. No further questions. Thank you.
The counsel seeks permission to move. So the defense counsel would like to call upon the defense witness 1, that is the accused, Jordan Schlanke. So firstly, in the interest of a fair trial, in accordance with Article 69 clause 1 of the Rome Statute and Rule 66 clause 1 of the Rules of Evidence Procedure, I'd like to repeat after me for the solemn undertaking. I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth. Thank you very much. And a very good afternoon to you, and thank you for being here. So the first question, can you just introduce yourself for the convenience of the court?
My name is Jordan Schneider. I am 45 years old. I was the former chief of the Special Committee for the Study of Demographics in Pune.
Okay, what is your primary occupation? Can you state that please?
I am an academician who specializes in the field of gene mutation. I have a PhD in the field of this.
Okay, thank you very much. So, can you just give me an idea as to why exactly did you launch these schemes under TAP, sterilization, forced abortions, forced pregnancies, and all those schemes that you presented?
There were some elements of Zuanian society that were a burden to the overall economy. This was a country that was struggling to continue politically and economically, and these burdens, as for the overall utilitarian good, it was considered necessary to consider such schemes and exercise.
Thank you very much for that. Can I ask you if these burdens that you talk about, these burdens were a particular race or a community?
As an academician, I don't recognize them as a race per se. It was just a group of people that happened to have characteristics that proved to be burdensome, such as antisocial elements, colliding with economic crime and disease.
Thank you very much, witness. Can you specify these characteristics that you're talking about, burden?
Those specific characteristics include a propensity for disease, which was a heavy toll on the exchequer of the government through welfare schemes. These were antisocial aspects such as the propensity to commit more crime disproportionately. It was societal, economic, and genetic.
So to reiterate you only, what you're saying is that there was no particular race, there was just individuals who had these genetic problems.
Precisely.
Thank you very much. So since you are a Shivanian, I'll present you with a situation. So if a sophist male marries a fellow girl, what will be the community status of that child born out of that marriage?
The community status of the child was irrelevant to the action plan.
Can you just tell me what will be the community status of that child?
She would be a sophist.
Okay, but she'd still have the phylogene of cystic fibrosis, am I right?
Precisely.
Okay, this is to bring to the notice of the court. So was that child who was having phylogenes and was a sophist by community sterilized under your scheme as well?
Yes.
Thank you very much. Now, coming to the next question, I'll be asking you, given your administration on these campaigns and you being the chairperson of SCD, what exactly, did you have complete control over the schemes of the act that you did?
My capacity and my involvement was just exclusively research and academic based. So policy that was legislated upon later was based on the research we produced. We were in no way involved in the legislature passing or the executive carrying out these policies. Implementation was not my focus.
So would you say that you did not have complete control over this act? Your Excellency, the council was just reiterating what he said in his previous question.
It was purely academic. There was
okay, thank you. Okay, thank you. So, who had this control over these schemes?
The implementation was carried out by the executive wing of the Zuanian government.
Okay, so what was your role during the implementation stage?
I was given the additional task of specifically overlooking just the sterilization so that it's carried out in an efficient and scientific manner. And even that was purely, again, scientific and academic based.
Thank you very much. Now, this point is to be noted, Your Excellencies. There are a few other questions, Excellencies. First, did you... Indeed, Your Excellency. So, did you have the legal obligation to fulfill the orders of the government that you said?
I was engaged in the capacity, I had an employment obligation, and to that extent I think we're engaged.
Thank you very much. Now coming on to your arrest part. So what exactly happened to you when you were arrested on the pretext of being offered an amnesty deal?
While still on Zuanian soil, I was intimated about I was promised an amnesty similar to that offered to Carl Puyo. And under that false promise, I travelled to the Labour Republic, at which point I was apprehended, arrested and brought before them.
Okay, can you highlight the part tricked, manipulated and coerced? Can you explain how you were tricked, manipulated and coerced?
So, there was an intimation made in the form of a promise for amnesty. That promise was a lie. The Labour Republic was a powerful government that had shown that it was capable of prosecuting, and there were actions being put against me, and that power imbalance was made worse by the lie that was the promise for this amnesty. It was exploited, and I stand for it.
Thank you very much. So you said your human rights were violated. Can you specify which human rights?
I believe I have a right to liberty, a right to my security, and a right against an arbitrary arrest. But
Thank
I'm
you
not
very
a legal
much.
professional.
What do you mean when you say the court should reconsider the trial?
I would be asking in specific for a stay on proceedings because of the illegal nature.
Thank you very much. No further question, Your Excellency.
Again, before we begin, we, undertaking our duty, inform the accused that he has a right under Article 67 and 69 to remain silent. His silence would not be deemed to highlight guilt, but might be used for his reliability as a witness here.
Yes.
Witness, is it true that you have a postgraduate degree in biotechnology and a graduate degree in gene mutation?
Yes.
Do you believe that Zhuan was one of the least populated countries in the world?
Yes.
Do you believe that Zhuan had abundant natural resources?
Yes.
So was there a pressing need for a Population Control Implementation Act?
The existence of an abundance of resources doesn't mean they're being efficiently exploited.
But the existence of Zhuan being the least populated country and you implementing a Population Control Act, what does that imply? You being an academician, as we say.
Population density is different than population in sheer numbers. You can be the least populated and still be extremely densely populated.
Alright. Do you believe that TAP was implemented strictly on genetic lines?
Yes.
Genetic lines. What genetic lines were pursued for the implementation of the TAP?
Genetic screenings were carried out. Certain genes that had a propensity to disease were identified, and those genes were removed from society.
Witness, I would say some activities. Just tell me if they are genetic or not in nature. Drug abuse. Is it genetic or not?
It can be.
Drug abuse can be genetic in nature. Arson.
Any antisocial activity can be influenced by your genetics when considering other factors, such as external socio-economic factors.
So you're telling me that if there was a prevalence of polygamy in fellows, that was because of their genetic structure?
Sure. So polygamy is a complex societal concept, but in an individual's behavior can be influenced by his genetics.
Witness,
Yes.
can be established from a statement that any socio-economic activity which is undertaken is deferred by a genetic infirmity or a genetic aspect?
It has influences, yes, based on my research.
Jordan Schlanke, do you testify yourself to be a sophist?
Yes.
Jordan Schlanke, do you understand from the years 1995 to 2008 the piracy operations which were carried out were by PTA operatives which were necessarily sophists? Do you classify piracy as a socio-economic offence?
Piracy is a social offence.
Then, by extending the same analogy, you being a sophist, are you also a pirate? By genes?
It's more complex than simply a genetic mutation necessarily leads to crime. I said that it influences activity. I didn't necessarily say that every pirate has been influenced genetically. I'm saying that genetics can influence piracy. That's the logical conclusion to be drawn.
Before I proceed, Courtmaster, could I be given a tap at expansion of 10 minutes whenever possible? Thank you. Were you compelled to make the Trident Action Plan in 2010?
I don't understand what you mean by compelled.
Compelled, were you ordered by the government to make the Trident Action Plan?
No.
It was voluntary?
The research that was carried out was on the basis of my degree.
Your Honour, so the next question, the Council would request you to move to para 24 of the MOOC compromise, if possible. Jordan Schlanke, in this paragraph on page 12, specifically line 7, it is written that the sterilization campaigns were overlooked and operated by you. What is the efficacy and the meaning of the word operated here?
I ensured they were carried out efficiently. I ensured that there were medical ethical practices followed, and I ensured that
Sorry to interrupt you, but that covers under the aspect of overload. What do you imply from operated?
Operated doesn't necessarily mean I carried out these procedures by hand myself.
What is
Operation includes management to the degree of scientific methods being followed. You're reading too heavily into the lines.
Do you believe that the Trident Action Plan would have been able to implement without your assistance?
The Trident Action Plan was the consequence of years of academic research that were based on my individual activities.
So you held an essential contribution to the plan?
Sure.
Alright, point to be noted, my lord. Witness, why did you spar those above 50 years of age or suffering from temporary illness?
Why did I? Sorry, I didn't follow.
Spare those who were suffering from temporary illness or 50 years of age?
Because they were unlikely to reproduce and cut up the gene.
Do you agree to the fact that you have you held any executive office impliedly or officially in Zuan? Unofficially or officially in Zuan?
No, I don't think my capacity as the SED chair was an executive.
Yes. Then how do you explain the increasing expansion of policies under Para 24 by introducing forced pregnancies, forced abortions, etc. by powers delegated to you by the Premier's office?
So the legislative expansions that were carried out were on the basis of my research. So within my academic capacity, I suggested certain policies that would be effective to alleviate the impoverishment of my country. And the expansion was a suggestion, not implemented in my ability or in my role.
But for the expansion of policies, you did hold governmental powers delegated to you by the Premier's office. Is that correct?
The governmental power delegated was academic, research-based, to suggest policy, not implement it.
Yes, but even if academic in nature, you had executive powers. Yes or no?
I do not believe that academic research is executive.
Where did you get funds for research before being appointed as SCD chairman?
My research comprised of fields that were just above eugenics. There were also gene mutation, there was a cure ailment of disease. I worked with the WHO. So my funding differed based on the research I was conducting at the time.
It might be useful for you to look at Annex 3.
Your Honours, before that we submit Annex to 4. We submit Annex to 4 as Exhibit B for this court. Under Annex to 4, Jordan Stanky, you have called you've said that you want to pursue politics in the strictest sense to the extent that the world follows your vision. What is your vision?
Objection, irregularity. In fact, it states that he does not want to pursue politics in strictest sense. Thank you.
His objection is very because he says he doesn't want to.
Your Honour, in the strictest sense, restricting politics, restricting the ambit of politics to the extent of... Yes. Yes, what is your vision, Jordan Stanky?
At the preface, you're citing a newspaper report that's been sensationalized. I don't hold that those terms from years ago were necessarily what
Your
I
Honours,
said.
we're citing an interview that Jordan Stanky gave in Labour Republic.
Sure, and interviews are often, interviewers often twist the words of the interviewees for their own economic TRP incentives. I
Do you
refuse to
believe
abide by that.
anyone who betrays the ethos of your nation is a failure?
No.
But you stated the same in the interview.
I'm refuting the validity or the veracity of the statements contained within that interview.
You're invalidating the same. Alright. Do you believe that you called Philos as irrelevant?
It was from years ago in an interview that has been reproduced in a manner I do not agree with.
That is an undisputed fact, Jordan Stanky.
The admissibility of a newspaper report.
No, an undisputed fact under Para 11. Could you please explain the same?
Could you repeat the statement?
Philos are irrelevant in the... One second, Jordan Stanky. Irrelevant in the uprising of the modern nation states, especially Iran.
They are economically unproductive. If that's what I said, that's exactly what I meant.
Did you possess a certain animosity against the community?
Depends on what you mean by animosity. I see them as unproductive.
You see them as unproductive. And you also criticized governments which tolerated the Philos.
By tolerated, I mean allow them to expand and continue to be a burden on economies.
Allow them to expand.
Allow
Therefore,
them to reproduce and be a burden on economies.
therefore you had an intention to prevent births between the philo community.
It wasn't philo-oriented. This isn't about them as a race. This is about the characteristics of certain...
We understand it's not about them being a race, but you wanted the philo group to not reproduce further. Is that correct?
You're using the
As
term,
your testimony stated. I'm
you're
not
using the
anything.
term philo to, and I've conceded to you using the term philo in the capacity for the convenience of the court. I've already testified that I don't identify them as a separate race or as a group of people that can be separately identified. I do think that these group of people that share these characteristics that are burdensome to economies should not be tolerated. If you want to continue to use the word philo for the purpose of this conversation, I'm okay with that. But do understand that's your word and not mine.
Alright. If you were so innocent, why did you go to Labour Republic in the first place to secure an amnesty?
Because my views on innocence and the overall utilitarian good is not necessarily shared by the ICC and the world at large, and we've seen as much when they persecuted almost persecuted Carlos
Alright. On that line, you're a believer of utilitarianism, is that correct?
Sure.
The greater good. To what extent can you or your actions go for securing the greater good?
To a large extent, it's why what I've dedicated my life's work.
So they can go to the extent of forced pregnancies, forced abortions, etc. Am I correct?
You are correct.
Can you define forced pregnancies?
In vitro fertilization.
Huh?
In vitro fertilization.
In vitro fertilization. Alright. Where were you on the night of, where were you on the evening of 15th May 2014, Shanky?
I'm unsure that I recall.
Huh?
I'm unsure that I recall.
So
It
you
was
weren't
5 years ago.
you weren't occupied somewhere specific.
Not that I remember.
Alright. Your Honours, in the same regard, under Article 69, we submit Annex 3, a conversation between Carl Spewel and Jordan Schlanke. Before that, Jordan Schlanke, do you also contend to refute the same?
Yeah.
Jordan Schlanke, you might not be a legal expert, but do you have any idea of the treaty signed by Zuan?
I can't be expected to.
Alright, as a researcher in the medical profession, do you understand the right of consent?
I understand the right of consent.
Yes. And the implications it has. The Hippocrates Oath, if I may also mention.
The
Hippocrates Oath, if I may mention.
It's not an oath that I've taken. Be very clear, I have not promised to do no harm. I'm not a medical professional.
But you were overlooking the aspect for its medical imbalances and its medical, medical expansion to the extent that you overlooked it so that it goes better.
Where were you from 2015 to 2018, especially in 2017 when the prosecutor was trying to contact you?
Within the territory of Zuan.
Within the territory of Zuan. Were you aware of your proceedings in the ICC or your warrant of arrest being issued?
It wasn't relevant to me at the time. I
wasn't made aware.
Then why was an amnesty deal relevant to you which stayed the proceedings of the ICC?
By that time, I was made aware, and after seeing what happened to Carlos Puyol, I decided that it was worth my work.
Therefore, it can be safely established that you were informed that an arrest warrant was issued against you.
I was made aware around the same time that the amnesty deal was offered.
Yes. All right. Thank you, Your Honor. No further questions.
Mr. Jordan Slanky, being an expert in genetics and gene mutation, is it correct to say that your aim in implementing TAP was finding cure for genetic diseases?
One of many, yes, one of many aims.
What would be the other aims of TAP?
Reducing the burden on the economy, reducing crime.
In your cross-examination by the prosecutor, you specifically said that antisocial behavior can be related to genes. Can you specify those particular genes?
The genetic research and the specific gene includes like the X86 that's been cited in a report that you've produced before the court. The specifics of the science is beyond the ambit of this discussion, but that's one example.
If I may direct the attention of Your Excellencies to page number 15, P35 of our memorial. It's MAOA and CDH 13 specifically, which the accused here refused to answer. Further, moving on, you refuted the reliability of Annexure 4, the interview. Annexure 4, the interview, are you specifically saying that they are defamatory?
I'm saying that the interview is a newspaper report in which the veracity of the statements that I've allegedly said can't be confirmed. No, I do not remember it being said like that.
But do you recall giving such an interview?
I recall giving such an interview.
In 2010?
Sure.
In the People's Daily, which is a newspaper, which is to say that it is right now in the public domain.
The legal expertise I leave to you.
In spite of it being in the public domain, a defamatory statement being in the public domain, you refuse to take any legal recourse. Is that correct?
I refuse to admit that I made the statement.
No, I'm saying against the newspaper, did you make any legal action since such comments about you is publicly published?
My support within society and my reputation in society, I didn't see as threatened, and therefore I didn't choose to sue.
He didn't choose to sue. I put to you that today you are challenging the reliability based on, since you are accused, you just want to get rid of your accusation and be acquitted. For the sake of that alone, you are bringing this reliability issue. Would you deny it?
Madam, over my career, I've been called a lot of names. My research is largely controversial. I highly doubt that suing every single newspaper that's said something would have been of any...
Thank you, Mr. Jordan. That will be all. Further, you also contested reliability of Annexure 3.
Could you remind me as to what Annexure 3
It's your text messages with Carlos Puyol.
Yeah, the dates are wrong. May 2014 is what the annexure says. But and he says that I've congratulated my premier on 3 years of leadership, but my premier was elected in 2008. That can't be accurate.
But yeah,
There's nothing wrong in congratulating your premier.
The exact statements was 3 years of leadership. He had been in power for 6 years at the time. He would not have taken kindly to me for getting the previous 3.
But isn't it correct that the TAP Phase 1 was implemented in 2011?
2010 and thereabouts. Yeah, that's when it was formulated.
2011. Point to be noted, your lordships. Further, is it not true that the implementation of TAP took place in 2008 during the global economic crisis?
You just said the implementation of TAP took place in 2011.
Okay. But the TAP policy was already in process. You joined SED in 2010. You joined what? Accused? Here, there needs to be certain clarity. You joined SED in 2010.
Don't get into an argument with him. Okay. You ask the questions and let him give the answers.
Much obliged, Your Excellencies. Much obliged, Your Excellencies.
I don't need to get into an argument with him.
Apologies, Your Lordship.
Further, if I put to you that you were involved in several WHO projects for finding cures in genetic ailments, is that not correct?
That would be accurate.
Also, is it not correct that genetically ill people were kept in specially designated laboratories. Is that not correct?
That is not correct.
If I may direct the attention of the panel to Undisputed Facts, page number 12, paragraph 24. It is clearly stated that suffering from genetic diseases, sequestered and isolated and were kept in specially designed laboratories. Further, is it also correct that forced abortion and forced sterilization were implemented?
Yes, that is correct.
Much obliged, Your Lordship. That's it.
Defense?
The council would like to call upon the next witness.
Yes.
Much obliged.
Thank you.
The council would like to call upon Devansh Agarwal, that is the defense witness 2, for the sake of examination in chief.
Good afternoon.
In the interest of the fair trial, the council will request you to repeat after me, please. I solemnly declare
I solemnly declare
that I will speak the truth,
that I will speak the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
Thank you very much, and a very good afternoon to you. And thank you for being here at the trial.
You can actually cut out all these pleasantries.
Indeed, Your Excellency.
You don't want to worry about what time it
Indeed.
is or be nice to them.
Indeed, apologies,
Just
Your
ask
Excellency.
the questions.
Indeed. So, can you just introduce yourself for the sake of court's convenience?
Yes, so my name is Devansh Agarwal. I'm 35 years old. I work with, I'm the CEO of BC Fintech Solutions Private Limited in the United States of America. And before going to the US, I was previously an active member of PTA and also an expatriate of Zuan.
So, how are you exactly related with the accused?
So we have been friends, and also I'm related in the professional capacity.
Okay, so what professional capacity are you talking about in the present case?
So so my company basically funds some of the research that Jordan does, and of course other researches for different purposes.
Okay, so what research projects did your company use to fund?
We've had many based on science and technology, and one of them being the Trident Action Plan.
So, to reiterate you only, your company was giving the money for research projects of TAP. It is to be noted, Your Excellency. So, since you are a very good friend of the accused, can you highlight what exactly did the accused seek to achieve from TAP and these schemes?
So the basic purpose of TAP was to, so it was aimed at the development of Zuan as a whole, to further sort of help the population of Zuan and for the betterment of the nation.
So what you're saying is, if may I reiterate, that it was for entire Xuan.
Yes.
Okay, thank you very much. So you also highlight eugenics. So can you please elaborate upon that?
So the whole idea that Jordan went by was, so TAP was basically related to the elimination based on gene pool system. So gene pool regulation. So here we have so we promote the good genes, and we sort of do not promote the bad genes. Here, this is done in light of the whole population of Zuan, where we try to protect the ones who are not at a threat, but the ones who are at a threat or have certain genetic diseases, we try to deal with them.
So just to clarify, this threat you are talking about is the threat from genetic disorders that you mentioned?
Yes.
Thank you very much. So, why do you support these eugenics? Can you give instances where eugenics have been followed?
So, in countries like USA, Japan, or China, China is still implementing this.
Thank you very much. Also, if I am considering if there was any harm to any particular community because of these policies which were implemented, as you already said, that implemented for entire Shuanian population, if there was any harm to a particular community, who can be attributed to the liability of that harm?
So essentially Jordan cannot be held liable for this.
Witness, if I may reframe, who can be held liable?
Who can be held liable? It would be the government, the sovereign.
Thank you very much. So Did Jordan held same intentions as the government if the government had those
No,
intentions?
so Jordan, whatever Jordan had done was in furtherance of his scientific temperament, and it was not personally sort of targeted towards the philo community.
Thank you very much. No further questions, Your Excellency.
If the council may proceed with the cross-examination. Victim, how much time does it take for a company to earn funds so as to facilitate an entire state machinery program for 10 million people?
I would not like to disclose these facts.
Okay. Can we say that it would take a substantial amount of time?
It depends on the kind of expertise and the kind of action plan.
Is it correct that you shifted to United States of America in 2010 June?
Yes.
Is it correct that before that you were in active service of the PTA before your unrequited, unrepresented denial and reliance of obligations by saying prior commitment reasons?
I would not like to comment on that.
Did you leave the PTA for professional reasons?
Well, yes. I wanted to further my interest, and I was offered a great opportunity in the US.
You deal in technological solutions, so why are you funding a program which is related to genetics? How is that monetarily beneficial to you?
So we are a technology-based company, and well, what we choose to do with the funds is essentially decided by us, and we would like to further certain research which would help the society. And being from Zuan, there is certain obligation or certain duty that I owe towards my country, which is to further develop the country. And if this research could help in the development of the country, I'm more than happy to.
What if that research is used for committing the acts of abortions and rapes?
So essentially these abortions take place in such a manner that firstly it's to further the interest of the population as a whole. Now if there is a threat, for example cystic fibrosis or something like Down syndrome, and if
you mentioned cystic fibrosis, I'm sorry to intervene. What is the implication of cystic fibrosis and what does it entail?
So I would not like to personally get into the details of it because I'm not a medical practitioner, but what has been told as a part of the policy for which we are donating certain amount has been said to us that it would further help in the development of...
You're suggesting that you earned that amount in... Witness, when was TAP implemented first phase?
The first phase was implemented in 2010.
Yes, and you moved to United States of America in 2010. Okay, so you've been funding the TAP as soon as you moved out to the United States of America. In 6 months, if deny if I'm wrong, in 6 months you were able to earn so many funds from your company, newly established company, on the basis of which you were able to fund the TAP. Am I correct?
I would not like to delve into that.
All right.
It's something that's personal to us.
Do you advocate elimination of the gene pool?
Sorry?
Do you advocate the elimination of the gene pool?
To further the interest of the society, to help the public at large, if there is certain sacrifice to be done, to prevent potential threat to the youth, to the future generations.
You being a CEO in a company, if an employee acts outside the course of his action, is he liable or are you liable?
I would not like to comment on this. But however, there is something...
we do not have time for howevers. In addition to that, did Jordan Schlanke view feelers in a distinct light?
Yes, because they had done more harm to the country as compared to the kind of contributions that they've made to the development of the country.
So if a community is said to make contributions to the country, they can establish certain harms too. They're legally allowed to provide certain harms, say in the sophist community in the form of piracy. Am I correct?
No, it is only the philo community with certain genetic diseases that are being targeted, not the
Your
entire
Honours, in
philo
the same
community.
regard, under Article 69, we submit Annex to 2. Annex to 2 is a news report in Zuan, which also submits that X36 nanogene, a genetic disease, was prevalent in all communities of Zuan and is now not prevalent in any of them. Yes, Your Honours. So the backdrop of Zuan is not entirely related to the philo community. So do you attribute all the backwardness to philo community as such?
This, the whole TAP action plan as a whole, the Trident action plan as a whole, has been targeted not only towards the philo community, but to the socially and economically and genetically backward.
Which other community do you suggest is socially, economically and genetically backward in Zuan, since you were a resident expatriate of Zuan, as I may put it?
I would not, I'm not aware of the exact demographics.
Is there it can be established that currently, incidentally, it's only the philo community. Is it right?
I'm not aware of that fact. But
Currently, in your knowledge?
In
Yes, Your Honours. Conceded. Thank you.
Good afternoon, witness. Is it correct to say that Jordan Schlanke considered philos as a genetically backward community?
Yes, because it was prevalent in their community.
Thank you.
But they did not.
Thank you, witness. Is it also correct to say that he advocated elimination of particular gene pool, which was defective?
Yes, that was only to prevent the potential threat that would be there for the future generations, and it was not applied to all philos, only the philos with
defective genetic gene pool.
Yes.
Thank you. Further, is it correct to you just deposed this saying that your company was formed in 2010?
Yes.
Immediately after the formation, you received funds to donate for a cause out of which you had monetary benefits?
That's confidential information. I would not like to disclose.
But you still funded the TAP as a policy?
Yes.
You also understand that you moved to US, which was under grave pressure of global economic crisis. Is that correct?
I would not like to comment on that.
No further questions, Your Lordships.
Thank you.
The council would like to call upon the defense witness 3, which is Dr. William Minusha, a national of England and a demographics expert.
Good afternoon.
So, could you introduce yourself for court's convenience?
My name is Dr. William Inuyashu. I am a professor at the Department of Population and Demographic Studies. I do research primarily into population crisis as well as demographic studies and sustainable maintenance of populations.
Okay, so you are a national of England and a professor at University of Ghana. Can you just tell me why are you interested in the present case of Xuan?
With reference to the philo community in Xuan, within my field, this is a subject that is being widely debated as to what the reasons and what the trends of the population of the philo community in Xuan have been.
Okay, so there's another question that do you consider the philos all over the world as a single group, single racial group, or are Xuanian philos particularly different from them?
Based on my research and understanding of the philo community, the philos globally are one race. There is no distinction between philos in Xuan and philos in the rest of the world. There are no cultural or physical distinctions between philos in Xuan and philos all across the world. So it is one single race.
Thank you, Mr. Inuyasha. Next question would be, being an expert in the field of demographics, can you throw some light on the population decline in the philos in Xuan between the period of 2008 and 2019?
The philos population, to give you a bird's eye view, is around 17.5 million in the whole world. And in Xuan, 13% of this population resides. There has been a decline in the population from 2008 to the present date. it is contemplated by certain people that this is due to anti-sterilization policies adopted by the government.
Sorry to
However,
interrupt you, witness. The question was specifically, what does your research show? What was the reason?
indeed, my research, however, also points to other factors which are causing this decline, such as an aging population and a population which is plagued with certain genetic conditions, which is decreasing the life expectancy of the philo community. Additionally, there is also a lot of emigration by the philo population to the rest of the world in search of opportunities. And there is also intermarriage in this community with other communities in Sichuan, which is leading to a dilution in their population.
Okay, counsel, coming on to the point that you said, immigration. I'd like to clarify if the philos have always been a migratory race, or did the immigration increase in that period of time, because there's a sharp decline.
Historically speaking, in Sichuan itself, the philos were originally a settlement who migrated to Sichuan from the Labour Republic. So yes, they are a migratory population. However, there are no historic statistics to show whether or not the population emigration has increased in the current days.
No, I'm asking specifically between 2008 and 2019. Was there any reason that emigration increased between that period?
Reasons for emigration can be
Or
attributed.
did it increase from before?
You can say that, and it can be attributed to a certain extent to the atrocities being committed against the philo community.
Okay, that would be all.
Thanks.
Excellency, no further questions.
Your Honours, the course employed by the council in the present questioning would be of analogy with regards to two statements made by the said witness, if may be proceeded. Witness, in your statement you said that philos are not a distinct community. Am I correct?
Indeed.
Because they cannot resemble the African American community. Am I correct? As an example. Just yes or no?
Yes.
Yes. Is it correct that you also refute that philos are not a distinct group as such because they migrated? Am I correct?
Not entirely. I did not state that their migration does not make them a distinct community. I have stated that they are not a distinct community owing to not having any physical or cultural attributes different from philos in the rest of the world.
But philos in the rest of the world do have. Do you concede that philos in the rest of the world then do have distinct characteristics from sophists otherwise?
Indeed, yes.
Yes. So philos of Xuan in reference to sophists, are they distinct or not?
They are distinct.
They are distinct, and those are based on objectifiable or subjective factors.
Yes,
as
it
you,
can be considered.
a professor of demographic studies, states.
Yes.
The second analogy is, you talk of American extension. One analogy. You talk of African American people, right? So, how did African American people come into existence again? If the defense may be allowed. Did they migrate to America from Africa?
Is this a question of science?
Yes. No,
well,
no. It's a question of fact because you mentioned the same.
Yes, they have migrated over the course of the years.
And because of their migration and their residing in America for a large period of time, did they get the distinct identity that you give them as African Americans?
That may be true, however, it's not a proper analogy based on my research and expertise to what is happening in Sichuan.
And what is the reason for you to say the same?
Look, when we take the case of America, it's completely different. My research and analysis to the extent of what America is much different. Okay. My case study is with particular reference to Sichuan.
Last question. You are of English nationality, you teach in Ghana, but you are so constrained with the affairs of Sichuan. Why is that so?
Because Sichuan is at the present moment my primary area of study.
Thank you, Your Excellencies. No further questions.
Good afternoon, witness. Is it correct? You just stated that the philo community are not distinct.
is it correct to say, since you are a demographic expert, that the philos in Xuan are a mix of anthropes and epistemologues?
I have stated that the philos across the world are not distinct from philos in Xuan. And yes, the philos residing in Xuan are an interbred between two different communities historically.
Yes. Also, is it correct to say that philos, particularly in Xuan, are subject to study and interest of across the world because of their distinct practices in unique craftsmanship, etc.?
With regard to the cultural and agricultural contributions that they have made, we do study their demograph in Xuan.
So it's true?
Yes.
Is it further correct to say that philos in Xuan have developed their own language called Mizit, which has 50 dialects?
Yes.
Is it also true that philos suffer a genetic disease, specifically in Xuan, cystic fibrosis?
Well, this involves certain medical expertise, but from my study, it is considered that a vast population in Xuan does possess a gene which leads to certain genetic degradations, and most people possessing this gene are from the philo community.
That will be all your questions.
Hello. Witness, is it possible to say that philos, globally speaking, are a race?
Yes, indeed.
Okay. Now, can you help me to understand further? Because of certain distinct characteristics possessed by philos in Xuan, can they be described as an ethnic group within a race?
As regards to whether they are, the Xuanian philos will be considered as distinct ethnic group within Xuan, yes, but globally as a community.
I'm not asking you about
within
global.
Xuan, yes.
Within Xuan, they can be considered as an ethnic group.
Yes.
Thank you.
Thank you.
The statements? Yes, please. Yes. We'll complete it. We'll complete in half an hour. Yeah, and for us also to deliberate. Yes. Ten minutes each. No extension.
Your Honor, before we begin, one simple submission is that we understand that the court is under the constraints of time, and because of that, the office of the prosecutor shall speak as fast as possible as the court could bear.
You will get your full 10 minutes.
Your Honor, what we're trying to request is, even if we're not able to establish what we want to establish completely in 10 minutes, an extension of time be granted so as to why. The reason we're specifying, and the time starts now. Your Honors, this is the first case of genocide in the ICC as of date, which is on the basis and on the trial chamber to be decided. The only other case, the only other literature that the ICC has on the case of genocide is the Omar al-Bashir judgment on arrest warrant, which was issued in 2009. It has been 10 years and there has been no judgment, no proceeding, no trial chamber on the same, and therefore this trial chamber owes a duty under international law to uphold this, the charges and uphold any prosecution if there is. Yes, Your Honors, for a jus cogens norm. Yes, Your Honors. Your Honors, we believe that the contentions have been established in our opening statements. Therefore, we will move into the substantive part of the same. Your Honors, with regards to the first contention, we submit that for establishing common elements of crime as enumerated in Article 9 of the Rome Statute, there have been
firstly, that feelers are a targeted group or not. The first question arises is if feelers are a targeted group or not. Your Honor, the prosecution essentially relied upon two aspects of it, that is a nationality and ethnicity, because the protected groups must be targeted with a way, or there must be an intention on part of the accused to destroy the group in whole or in part as such. The as such aspect of it suggests, as reiterated in the Akayesu judgment, prosecutor versus Akayesu in ICTR, it suggests that even if an individual is targeted because of his group identity, that would be considered for the purposes of genocide. And in this case, through the course of the witnesses, we have established, especially defense witness number 1, 2 and 3, we have established the following criterions. Firstly, that there was a distinction between philos and sophists which was so identifiable on the basis of race, nationality, to the extent of philos of Zuan and philos, to the extent of ethnicity with regards to common practices such as prevalence of polygamy, prevalence of homeschooling, prevalence of farming in sea mineral lands and them being traders, etc. and other racial factors as had been enumerated by Dr. William Inuyasha DW3, that we can safely establish that philos were in fact a protected group under Article 6. Next, we move on to the fact if the accused had the intention to destroy the group in whole or in part. The accused had the intention as submitted in Annexure 2, 3 and 4, and which are Exhibit A, B and C. We've submitted how the accused made use of derogatory languages. And in the case of prosecutor versus Musema, derogatory or humiliating languages are characteristics of a genocidal or a specific intent. Your Honor, here we argue that the specific intent contains two forms of intent. Firstly, the general intent under Article 30, which is to be fulfilled by intent and knowledge. The Article 30 intent was already fulfilled because Jordan Schlanke had knowledge of the same with regards to him having studies in anthrobiology and other interdisciplinary sciences, as mentioned in paragraph 11 of the Moot Compromise. In addition to that, he also had a specific intent, as himself he stated in the witness testimonies, that he did not want the propagation of philos, and therefore he said that he intended those measures to prevent births within a community. And defense witness 2 highlighted how that community incidentally happened to be the philos, because we also established through the course of prosecution witness number 1, prosecution witness number 2, 3 and victim witness number 1 that no other community, be it the sophists or other communities existing in Zuan, had undergone the sterilization operations. So even if the defense comes here and contends that the TAP was made for all, it was not implemented for all. It was implemented for philos in specific with the intention to destroy them in part or in whole as such, which has been established by defense witness number 2 when he says that philo population has dwindled considerably with the population of 50%. And the characteristics and factors mentioned in defense witness number 3, which are emigration and other natural factors, Your Honours, it is put to the knowledge of this court and to the councils, which the councils cannot necessarily digest, that can a 50% population decline actually occur just by the nuances of emigration or other environmental factors? And if it did, why was it not there in the history of Zuan? Also, why did not a single other community complain about the same? Lastly, since we have established how the intention to prevent births was there, this also characterized them to cause a harm, serious bodily and mental harm, which was there as established by prosecutor witness number 3 and victim witness number 1. This principle of harm is highlighted in the Lubanga case, which relates to mental, economic and physical harm, as already been established in this court. The third aspect of it is manifest pattern of similar conduct intended to cause destruction. The very formation of TAP in 3 phases shows how systematic it was, and in paragraph 113 of the Al-Bashir judgment and the memo relied upon by the prosecution itself, we've established as to how the the TAP was implemented in a systematic manner. This systematic manner, Your Honours, is how the fellows were targeted specifically because in the carb of genetic or social infirmities. Your Honours, we fail to accept the ideology and analogy that crimes are genetically established, and nowhere it has been proved by any of them as to how the same is there. Your Honours, if the court is satisfied that genocide under the charges of establishing serious bodily or physical harm under 6B, 6C, intending to calculating measures of life to prevent, to cause destruction in the group, and 6D, intending to prevent births in the group were established by the accused, we move on to his individual criminal responsibility under 25(3)A and 25(3)D respectively. 25(3)A talks of co-perpetration. Here we're charging Jordan Schlanke as a principal offender, and this principle has been highlighted in the Lubanga case itself. In the Lubanga case, there was reference to the common, Your Honours, we've marked it in pages 7 to 13 of our written submissions. 7 to 13. Your Honours, in that specific case, there was laid down two principles. Firstly, the objective principles that were laid down was that there was a common plan, which the TAP was, as has been highlighted by all the witnesses and victims, and there was a specific necessity of Jordan Schlanke to be present. That is a necessary contribution by him, which was established in his testimony in the cross-questioning by the prosecution. Therefore, he has to be held liable under 25(3)A. Even if that is not to be done so, in 25(3)D, he is held as an accessory, and the same has been highlighted by, in the same context of common plans, of necessary contributions in the Maburishima judgment. Your Honours, we have not contended a charge on the same, but according to the witness testimonies, Jordan Schlanke contested and said that he was aware that such remarks about the fellows being against ethos of a nation and fellows being irrelevant were in the public domain. So even when we've not charged the same, it is brought to the light of the court that under 25(3)E, in reference to the crime of genocide, individual criminal responsibility lies when a person publicly incites others in the same aspect of committing genocide. Your Honours, if the court is satisfied with the responsibility, we move on to the contention of arrest. Before that, Your Honours, if you may refer to Compendium 1, Your Honours, the pink flag specifically, in the Akayesu judgment, again, the formulation of as such is there. Your Honours, with regards to the arrest, yes, Your Honours. Your Honours, with regards to the arrest, Jordan Schlanke was informed of his arrest before amnesty deal was offered. That means that he knew that proceedings was there, he knew that arrest warrant has issued, still he willfully did not come, and before that he was fled or cannot be found principle applied under 61(2). And therefore, the proceedings could have been proceeded, and any challenge from the defense with regards to the manner of arrest is deviated and contended by the Kerr-Frisbee doctrine in reliance to the Malacaptus Benedictus doctrine, which says that any arrest made for universally condemned offences. Universally condemned offences have been defined in the Nikolic case and Lubanga case respectively. In the Nikolic and Lubanga case, universally condemned offences include such which are against international community as a whole, and we believe genocide being a jus cogens norm as established by the ICJ in its ruling of the Genocide Convention, we believe that it is a universally condemned offence as such, and therefore any irregularities with the arrest should not be considered even when there were no irregularities, because it has been established that the sovereignty of Zuan was in no way violated, and even then there is a vertical relationship that the court holds with regards to other states, which has been established in the documented case. Your Honours, if the court is satisfied with the arrest, we move on to our final submission with regards to piracy. Your Honours, under the regulations of the Office of the Prosecutor, read with Rule 99, the Office of the Prosecutor is bound under Regulation Your Honours, if we may be allowed 2 minutes. Your Honours, Your Honor, this contention that we're contending is important. Just an extension of 1 minute or 2 minutes if requested. Thank you, Your Honor. Your Honor, this contention under Regulation 49 and 65 of the Regulations of Prosecutor, the prosecutor has to identify such assets, instrumentalities of crime which were used, as highlighted by witness number 2 and witness number 1 of the prosecutor and victim witness number 2. We've established how the piracy operations still continue and how the piracy operations contributed to the TAP, how they contributed to the PTA coming to power, because PTA contested elections before 2008, but they failed. But they won because of monetary majority as per paragraph 13 of the fact sheet. That means that they won, they had some monetary majority, and even the reports. Yes, Your Honor, the piracy, yes, Your Honor, yes, Your Honor, it was planned since 1995. Yes, Your Honor, the original soil theory was the reason of why it was there. It was planned since 1995. Piracy operations contributed to these acts of genocide in that way. And the piracy operations, why they're also illegal and why forfeiture is 30 seconds more. Why?
We got it.
Your Honor, if we may be allowed just to state the legal provisions of why the piracy operations are manifestly illegal also.
So we are familiar with the law.
Yes, Your Honor. We made the same in the written submissions, pages 25 to 30. Yes, Your Honors. Yes, Your Honors. Yes, Your Honors. In addition to that, there was an intention of the same. Yes, Your Honors. Yes, Your Honors. Your Honors, if it may satisfy the court, may the counsel read the prayer? Yes, Your Honors. Your Honors, due to paucity of time. Due to paucity of time. Yes, Your Honors. No, Your Honors, if we may be allowed to reiterate our prayers as our oral submissions.
In your
Yes, Your Honors, we understand. We completely understand and comply with the court. Thank you, Your Honors. It was a pleasure arguing before this court. Thank you, Your Honors.
They will. For the valedictory. Wasting time.
Your Excellencies, the legal representative, that's Labour Republic, legal representative of the victims in the instant case, that's Labour Republic, contend that in the instant case, that is prosecutor versus Mr. Jordan Sklanky, the accused had committed a series of varied acts that have aggravated and has harmed the victims in the instant case, that is the philo community of Zuan, the Zuanian philos, in varied aspects. The varied aspects include they have been subjected primarily to forced pregnancy, forced abortion, social segregation by the accused in specific. In this respect, Your Excellencies, the chief and cross-examinations of the accused is given, the defense counsel wishes to give primary importance to the chief and cross-examinations of the accused, Mr. Jordan Sklanky. Mr. Jordan Sklanky has explained the theme of the policy when he answers to the prosecution's question, that is, when a philo woman marries a sophist man, the child is identified by the community to be of a sophist. But then, the philo woman with the defective gene is still subjected to forced sterilization. And also, when the accused, Mr. Jordan Sklanky, mentions that whom did you exclude? He answers that only those who were unable to reproduce, only those above the age of 15, only those who were very less likely to reproduce were spared out of the policies. That in itself proves the special intent of the accused, that he specifically didn't want the philo gene to be transferred.
And this goes in very much well with the Akayesu judgment, that is the prosecutor versus Akayesu, wherein an issue of systematic rape of the victim women were involved, Your Excellencies, wherein the court discussed and explained how forced pregnancy, including systematic rape, could amount to genocide. That is to say, the court discussed that when the women are being impregnated through the man's gene, so it is ensured by the perpetrators that the gene no longer exists. Exactly the same as what Mr. Jordan Slanky in the instant case has done. He has not only stopped with the community's identification of the children being identified as sophists, but he has also went ahead and attempted steps, brought in scientific steps such as sterilization and forced abortion to completely eradicate the gene out of the gene pool, the phylogene, that is the victim gene, out of the gene pool and the demographics of Zuan. So this is the prime contention, Your Excellencies. And moving on to further particular means of harm that my victims have been put forward to, they have been subjected to social segregation, Your Excellencies, wherein the undisputed facts clearly state that they have been subjected to laboratories. The undisputed fact says that people with genetic diseases have been put to laboratories, and social segregation, that is isolating them from the social life, was being practiced. So without further ado, the council finds it more relevant to discuss with the problems with the policy that is being alleged to be the genocidal policy, Your Excellencies. So we contend that the accused had the prior knowledge for the fact that the policy was not at all neutral. The accused actually aimed, when asked for in the examination, what was the aim of implementing TAP, the accused answer to cure genetic ailments. If at all, curing genetic ailments was the actual motto of the accused could have adopted for alternative methods. And the Council for Victims have cited in their memorandum in page number 15, paragraph number 35, two alternative methods have been cited, that's the somatic and germline gene therapies. It is to be understood that, Your Excellencies, the accused is a world-renowned scientist. He has a good repute and he has a good in-depth research in the field of gene mutation. So he could have opted for these methods, wherein these methods have the effect of involve a simple process of taking away the defective gene, curing it, and inserting back to the concerned persons. So this would have ensured that the gene still stays in the gene pool and the demographics of the country without the presence of diseases. So with regard to the prior knowledge argument, Your Excellencies, so it is very well given in the undisputed facts that page number 7, paragraph number 9, that cystic fibrosis, a genetic disease, a deadly disease, was prevalent among the philo community. So also in the testimony given by the accused mentions that criminal activities are influenced by genes. Violent behavior, the way they behave, is influenced by the genes. So this has to be read with the undisputed facts, page number 8, Your Excellencies, wherein the undisputed fact says that Jordan's animosity towards the entire philo community was due to the social or economic backwardness. So he very well knew for the fact, even before entering TAP, that they were socially backward, and this social backwardness was influenced by the genetic backwardness, and he wanted to frame such a policy. That's why he came up with a doctored report. This doctored report has been testified by the prosecution witnesses. So by doctored reports, we mean that he came up with a made-up report so as to ensure that, to paint a false picture, to paint a bona fide picture, the TAP phase 3 was entirely dependent on TAP phase 2. That's the report. Wherein we contend that the report in itself stands doctored on light of the fact that in undisputed facts, page number 7, paragraph 9, it stated that non-violence is a pertinent practice of the philo community, that is the victim community. This stands in direct contradiction to the report, what the report says, wherein the result of the report has stated that philos have contributed to the highest amount of criminal activities. Furthermore, the report also states that the smaller amount of crimes which have been alleged as per the report to be committed by the philos were used to fund the larger amount of crimes. As per the perusal of the undisputed facts, Your Excellencies, piracy, which is a large crime, was committed in large by the sophists between the period of 1995 to 2008, when foreign explorations entered the waters of Zuan. So if at all this logic of the phase 2 report has to be bought, Your Excellencies, it is a logical fallacy to state that when sophists who already hate philos, when there is a political when there's a political competition and hatred between these two races, why should the philos who commit these smaller crimes help in funding the sophists who commit these larger crimes? So we fail to understand. We contend that on light of these facts, the report was purposefully doctored. And it is to be understood that, Your Excellencies, particularly when phase 3, the crucial genocidal policies such as forced pregnancy, forced abortion, and social segregation were specifically about to be implemented, the accused, Mr. Jordan Slanky, it is at that point of time where the undisputed facts say that Carlos Puyol has delegated powers to Jordan Slanky. Until then, the delegation did not take place. So here is where the accused enters into the ambit of Article 25, that is individual criminal responsibility, wherein he undertook to overlook the policies by himself. He undertook to master the policies by himself. It was in fact the SCD in the first place which recommended to the government such a policy. And specifically when it came to such crucial policies, aspects of TAP, Jordan's agencies took over the control. The same fact, Your Excellencies, is being testified by the farmer, that's the prosecution witness number 3, wherein he gives an instance about how forced abortions were carried out without even getting the consent of the daughter, who was at the first position a minor. Forced abortion was carried out. She was not allowed to. The victims were not even allowed to bear their own child, Your Excellencies. So their fundamental human right to reproduce and their right to have their race being recognized was at stake. Also, Your Excellencies, the witness testimonials of prosecution witness 1, wherein they testify to the doctrine of report, the purposeful implementation of the malified implementation of TAP cannot be disregarded because of the in-depth research that is being carried out. Also, Your Excellencies, Philo's population decreased to 15% is being testified by the prosecution witness number 2, Your Excellencies. Further, we move on to the contentions in the memorial. So the victims have been suffered to physical harm on account of hate crimes being perpetrated against them by doctoring of these reports, which is also given in the undisputed facts. Further, they are also subjected to emotional harm by all these particular crucial policies, which did not even allow them to reproduce, which the state used media as per the undisputed facts. Jordan's agencies used media in the instant case to actually spread hatred, to increase the amount of violence and hatred against the Philo community. Also, Your Excellencies, moving on. Also, Your Excellencies, now I wish to contend about the Operation Dexter, that's Labour Republic, in victim witness number 3, who was the chief of conducting this Operation Dexter, has clearly testified that the accused was not promised, was just assured of a possibility. Yes, 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 Your Excellency.
There's this whole conspiracy, the whole implementation of this of the Trident Action Plan resulted in great prejudice to your community of people whom you represent, and that actually violated their human rights, and it finally ended up in what you say is genocide. Correct?
Yes.
That's your answer, right?
Yes, yes.
So, if you have unless you have some absolutely new point to make, I think you have actually made your point quite clearly, and I think the victim's position has been put quite clearly. Unless, of course, there is something new you want to say. I just have one question for you.
Yes, Excellency.
Are you content with the manner in which the Prime Minister has been dealt with?
Your Excellency, we don't actually contend. We are completely focused on the harm that's being created.
No, but I'm asking you, are you comfortable with the manner? But your community is not complaining about it's like playing Hamlet without the Prince of Denmark.
Given a chance, we would wish to even prosecute Mr. Carlos Puyol, Your Excellency, because in fact, as per the undisputed facts, he in fact wanted to neutralize the Philo opponents. So, annexure number 3.
So, are you looking for a scapegoat?
Sorry, Excellency.
Are you looking for a scapegoat in Jordan?
Okay.
What I mean is, are you looking for someone to hang for the crimes that you say have been committed?
No, Your Excellency. The most appropriate figures, the two most appropriate figures to all the harms that the victims in the instant case have suffered is one Mr. Jordan Slanky, who has administered these policies. One particular contention in light of the annexures as an answer to
But
this.
Jordan says that he is a scientist, he is an independent.
Sorry,
virtually
Excellency.
an independent contractor, that's what he's saying.
Sorry, Excellency. Your
Jordan is
Excellency,
saying
Annexure 4 clearly brings to our notice, the interview brings to notice the political motive that the accused had been having. So he did not have the chance until 2010 to actually enter into a political environment to implement all these policies.
He had other great dreams through this, isn't it?
Yes, Your Excellency. And whereas at the same point of time in 2010, Carlos Puyol did not have the political ambitions, the political power but he wanted to neutralize the fellows, but he did not find the effective means to evade a forum like International Criminal Court, for which when both of them met was the actual genocidal circumstance created, Your Excellency.
Thank you, that's fine.
Can I move on to the prayer?
It's yeah, I think not necessary.
Much obliged.
Good.
Firstly, since there has been a lot of concern regarding the newspaper report and a lot of contentions by both the prosecutor and the legal representative of the victims have been based on the newspaper report, the council would proceed to state that in the Bradnan case, ICTY has clearly stated newspaper reports are not probative evidences. Further, even however, if the honorable bench uses its discretionary powers and considers those newspaper reports, the accused, that is the defense witness 1, has clearly stated that in any inbreeding, if X36 became dominant, that particular gene was aborted. He never stated that X36 became dominant only in the inbreeding of the fellow community. However, the council would also like to state, since the major contentions rely on what are the intentions that the accused hates the fellow, the Office of the Prosecutor and the legal representative failed to highlight the fact that there has been, there was a difference in the communication. For the accused, a fellow meant any individual who was socially, economically and genetically backward, wherein for the Office of the Prosecutor and the legal representative of the victim, a fellow means a racial group. So thereby we also state to, we also highlight this very difference, inherent difference which has been there all through the proceeding. Further, under the very Latin maxim, falsus in uno, falsus in omnibus, which states that false in one thing means false in everything.
False in small things means
apologies.
that you are saying not very right things with regard to the big things.
Apologies.
Falsus in uno, falsus in omnibus.
Apologies, Your Excellencies. Under that very Latin maxim, the accused questions the credibility of prosecutor witness 2, who in the deposition stated that the tests were doctored, but in the examination stated that the tests were not doctored. Further, he also goes on to state that the major decline in population, that is 50%, could not be possible unless there is some artificial interference with that. He fails to recognize the fact that under page number 32 of the moot compromise, the sophists were the most populated community, wherein in 2018, after the Trident Action Plan, as stated under para 6, they have become the third largest population, which is a population decline of more than 50%. Further, prosecutor witness 3 stated that was a forced abortion. In the deposition, it was clearly stated that she stated that it was a voluntary abortion, and her child aborted because she was brainwashed, and that is the discrepancy again.
So their position is that although it was voluntary, it was coerced.
Indeed, Your Excellency, and that is what the council is highlighting, that she stated it was a forced abortion, wherein it is clearly given in the deposition it was a voluntary abortion, but as she stated, it was due to brainwashing. So there is this complete... Indeed, Your Excellency, so the further contention about that very witness is that accepts the fact that she follows all cultural tradition of the Shuanian population. One of the cultural tradition is homeschooling, and she states that her child went to the school and she was mocked right there, and thereby there is a contradiction there as well. Coming to the Latin maxim applied in Victim Witness 2, the Victim Witness 2 stated that the ICC gave him some undisclosed amount of money, but in the deposition it is clearly given it was the Labour Republic who gave him undisclosed amount of money. Also, continuing with Prosecutor Witness 1, he stated that for the accused, it was only negative eugenics that was purgatory panacea. But in the present case, it is an undisputed fact that it was not only negative eugenics that was followed, but also positive eugenics. Further, moving to Victim Witness 3, he stated, it's very pertinent to note that his expertise does not is not in luring oppression, rather in thwarting major terrorist activity. He fails to recognize the self-determination clause that he mentioned in the deposition. Now, for the convenience of the court, the counsel would like to elaborate what is this self-determination clause. So, as they have stated, so self-determination clause is one in which the requested party has a liberty that they can call any offence a political offence. Now, it is pertinent to note and also accepted by Victim Witness 3 that they have ratified the Genocide Convention. Article 7 of the Genocide Convention clearly states that genocide cannot be held as a political offence, and thereby their extradition treaty has also, since it is a ratification, it is binding on them, thereby the extradition treaty also included this very fact. Further, in the trial under Article 64, Clause 6E should protect the rights of the accused prior to the trial, and thereby we also contend that besides the violation of the procedure established by law, there is a violation of right to liberty and security and the right of the accused against arbitrary arrest. In the Trava Perpetua of Article 9, it was clearly stated unpredictability is a major component of arbitrary arrest. Luring operations like this is completely unpredictable and arbitrary. Further, it violates the liberty of the accused, as held in HL versus UK. ECHR held that deprivation of liberty is to be determined from the amount of control that the person had on the accused. Here, the accused could not act in his free will as he was under false pretense. Further, it also leads to a violation of Part 9 of the Rome Statute, which talks under which Article 97 obliges the state that the state shall respect the pre-existing treaty obligation, which was not done in the present case. Further, the council also accuses the prosecutor for encouraging this very act, as under Bragwazia, it was held that it is the duty of the prosecutor to ensure that the trial proceeds to respect the rights of the accused, which the prosecutor completely failed to do. Further, reparations must be given, as held in Lubanga, quote, interest of the world community to try persons accused of the most heinous offences, crimes, is outweighed by the need to sustain the efficacy of the judicial process, which was not done, and thereby also a violation of fair trial in ICC. Moving to my second contention, that the accused must not be held liable for Article 6. Firstly, as mentioned by the Office of Prosecutor, that the accused should be liable under Article 6B does not stand, because as already mentioned by my co-counsel in the opening statement, that the Trava Perpetua of Article 6B talks about permanent mental impairment. The facts are not sufficient to sustain the same. Further, Article 6C does not stand as well, because it talks about imposition of such life conditions that a person cannot live. Impairment of the medical facility, does not providing food, comes under those conditions. In the present case, again, there are not enough facts to substantiate this very clause. Moving, how he is not liable under Article 6D, it is pertinent to note that genocide is committed because of membership, not of individual identity. The accused has gone again and again stating that it was done only because it was done on individuals only who had those genetic diseases. Further,
your witness number 3 has stated that Gilu community in Juan is an ethnic identity.
Indeed.
And the Genocide Convention protects 4 groups: and one of them is ethnic identity. So what you have to say?
Indeed, Your Excellency, for that, since the prosecutor had a burden of proof to prove all the 5 elements, the council would proceed with the 3rd element of intention, which is not fulfilled, and thereby the accused cannot be prosecuted under Article 6. Now, in Al-Bashir case, it was talked about the specific intent, that is dolus specialist. It is not present in the present case. First, as mentioned by the accused, if a sophist guy marries a fellow female, the community status of that child is sophist, but he would still have that fellow gene and thereby would still be sterilized. Further, the Shuan Population Control Implementation Act was for the entire Shuanian population. The legal representative of the victim has gone to state misleading facts wherein it was stated that social segregation was of fellow community. The undisputed fact clearly states that social segregation was for anyone who had any form of genetic disease.
So what you're saying is that there was no discrimination.
Indeed, Your
Between
Excellency.
the two groups.
Indeed, Your Excellency. Further, when the accused expanded the process, it was for the ultimate goal of eugenics, wherein he also included the positive eugenics, which the Office of Prosecutor and the legal representative of victim failed to identify. Further, even if the honorable bench passes a verdict of genocide, it cannot be attributed to the accused, as under Article 33 has a protection. First, he was under a legal obligation to abide by the government order. Secondly, it is pertinent to know for the other 2 contention, it is a burden of proof on the prosecutor to prove that he had the knowledge, which in the contrary, the prosecutor failed to do so.
Have you got to follow illegal orders?
Sorry?
Do you need to follow illegal orders or perhaps against public policy?
Indeed, not Your Excellency, but in the present case,
Contrary to international criminal principles of international criminal law?
Indeed, not Your Excellency. In the present case, it was a legal order. It was a legal order under which the accused was bound to act because it was passed by the government. Further,
no, that's not what.
Genocide specifically provides that that's an exception to say that he has followed a legal order, because there is no excuse in a charge against genocide.
Indeed, Your Excellency. That is why the council would like to state the legal obligation was not of genocide. In Ekman case, it was clearly stated for it to be manifestly unlawful, it should be like a black flag. It should be like clearly prohibited. In the present case, the legal obligation was not of genocide. Further, also that he did not know of the intention of the premier would be established, as we already questioned the credibility of Annexure 3, as the accused has clearly stated that he was that firstly it is there is an inherent discrepancy, and secondly it's a transcript of 2014 and tab came in 2010. So thereby he should be relieved under superior responsibility under Article 33.
Thank you.
So just one little question, like in this case of the Eichmann, going back to, that's why I asked you that question at the beginning. So the point you're making is the distinguishing mark of a manifestly or unlawful order should fly like a black flag, it says, above the given order as a warning reading prohibited. In other words, at the very point, at the threshold of being given that order, it must be manifestly written all over it, so to speak, that it was manifestly unlawful.
Indeed,
so
Your
what you're saying is
Excellency.
that is not the case here.
Indeed, Your Excellency, because the accused was only given a legal order to form the policy according to his research, and thereby...
No, the accused was given an order that didn't manifestly manifest itself as being an illegal order.
Indeed, that is what...
And he, in his enthusiasm, your argument is, has been a scientist who thought that this was all for the good of the nation, implemented that particular order. That's
Indeed,
right?
indeed, Your Excellency, since it was not manifestly unlawful, he acted in his scientific temperament. Thereby, I rest my case.
Thank you. Good, very good. Shall we just wait? Yes, pleasure. We will adjourn for 10 or 15 minutes. And we probably come back in 10 or 5 to 10 minutes. Yes. Yes.
I request all the audience to please be seated. You're not supposed to leave till the valedictory ceremony gets over.